last night was restful for everybody. I speak peace
Recording
to
in progress.
everybody that will participate today. And this is day 2 of the Tribunal's hearing, hearing a joint motion brought by the Assembly of First Nations and Canada for the Tribunal's approval of a compensation settlement. This morning, we'll be hearing from the Caring Society, and now the floor is yours if you're ready.
Yes, good morning. Thank you, Chairperson Marshall Dawn, and good morning to you, Member Lustig. My name is Sarah Clark, and I, along with my co-counsel, David Taylor, are here today to represent the First Nations Child and Family Caring Society. I want to start by letting you know that I am in Bracebridge, Ontario today in Muskoka, the lands of the traditional Anishinaabe and lands covered by the Robinson-Huron Treaty and the Williams Treaty. We want to start today by honoring the children, all of the children, who have been victims of Canada's discrimination, going back generations, as we know. I want to start by referencing the Royal Commission on Aboriginal Peoples that was tendered as evidence in this case, and that in our view formed a big part of the backbone of how we got to this point. RCAP tells us that children hold a special place in Aboriginal and First Nations culture. They bring purity of vision to the world they teach. They carry within them the gifts that manifest themselves as they become teachers, mothers, hunters, counselors, artisans, and visionaries. They renew the strength of the family, clan, and village, and make the elders young again, and with their joyful presence. We echo the words of our friends from the Assembly of First Nations, who spent some time referencing Elder Bobby Joseph. From the Caring Society's perspective, Elder Joseph had a profound impact on this case, and his evidence and testimony is very important to what we are doing here today. He said in his testimony to the tribunal, "One of the stories that I want to tell you about today is about how all of that became very damaged, and in some cases extremely broken, to the extent that there was a real interruption in our ability to care for our children in the ways that we had since time began." And I think it's going to be important in the context of our discussion to understand that there were reasons, of course, for this loss of ability to care for our children like we always had done before. As a result of the experiences of newcomers coming to our territory, the residential schools, and colonization in general, that there was a huge, huge harm upon our families and communities. And I just want to say that in spite of all of those things that were broken and the things that we were not able to do for our children, that we were deeply, deeply in love with them, and that we still deeply, deeply desire to re-empower ourselves to raise our children in the way that we want to. Now, as this panel is aware, the Caring Society is a co-complainant in this ongoing human rights complaint going back to the year 2007. This complaint has always been focused on the victims of Canada's discrimination, its children and its families, who have been waiting for vindication, acknowledgement, and real change at the level of kids and families on the ground. Today, we are here to consider the joint motion brought by the Assembly of First Nations in Canada, seeking to have the class action final settlement agreement approved by this panel by either making a declaration that its terms meet the requirements of the existing tribunal orders, or by amending those orders to line up with the class action final settlement agreement. Now, in our view, as you know from reviewing our materials, the motion ought to be dismissed. But we want to be very clear. It is not because the Caring Society thinks that the settlement is bad. It's not because the claimants identified in the settlement agreement won't receive badly deserved compensation. The breadth and scope of Canada's discrimination should not be understated. The Caring Society's position is not about defeating the final settlement agreement. It is about protecting and safeguarding the rights of children that have already been won. It is about protecting the hard-fought victories that already sit in the hands of the victims identified by this tribunal, and seeking to build upon those and ensure that we don't compromise legal victories that already exist. In this case, have been challenged and affirmed. And in our view, those decisions must be respected. The Caring Society wants to first acknowledge that the settlement is historic, and the amount of $20 billion will compensate many of the victims of Canada's discrimination within the parameters of this human rights complaint. It is tempting to see the number of $20 billion as nothing more than a slam dunk. It is an extraordinary amount of money, and we honor and respect the work that has been done to build this moment. But the enormity of the number is not something to be celebrated. The enormity of the number is a result of Canada's long, systemic, sustained, and willful discrimination perpetrated by the federal government against First Nations children and their families. And so it is tempting in this moment to simply accept the number and put an end to a very, very long fight for compensation for the victims of Canada's discrimination. There are many non-legal reasons to just accept this number. But in our view, we must take great care to ensure that the steps we take within this sacred human rights process respects the tenets of our human rights regime and upholds the rights of all First Nations victims in this case. The approach to implementing human rights must be flexible. We agree, but the rights themselves are not. In addressing this submission, in this motion today, I will be making 4 principal submissions. First, it is our respectful submission that the tribunal does not have the jurisdiction to grant the relief requested. And I want to be clear, it is not about whether or not the tribunal has existing ability to assist the parties in implementation. It is about the jurisdiction to interrupt 2 fundamental orders that have been made: entitlement to $40,000 for all of the victims, and the eligibility of who can and cannot access that $40,000. On this issue, I will be addressing the case law and also examining the tribunal's unique and specific retained jurisdiction in relation to this case. It is not about whether or not the orders should stand. It is about how they should be implemented. The second submission I will make is focused on the key departures that are under the final settlement agreement. So in our view, to the extent that you do have the authority, and I think Member Lustig, your question yesterday was right on point with respect to this, to the extent that you do have jurisdiction over the final settlement agreement and its terms and conditions, we would say that it is critical that you examine the key departures from the final settlement agreement to make sure that your orders, both in spirit and in letter, are properly implemented. With respect to my third submission, again, if you find that you have jurisdiction to consider the relief that is being requested, in our view, you must consider that at this point in time, the request that is being made is premature. There remain a number of unanswered questions about particular groups of victims who may or may not be entitled to compensation under the final settlement agreement, but who are, we know, squarely eligible for compensation pursuant to the tribunal's orders. In other words, how can you decide if this motion ought to stand or fall when you do not know the actual impact to the very victims that you have identified in your previous rulings? We submit that without more information, you cannot actually decide this motion with any level of certainty, and an inherent injustice would flow if you don't know who is in and who is out. Finally, I will be reviewing the principles that we say, and hopefully you agree, ought to form the basis of your analysis should you find that you have jurisdiction. You know, I take the words of Justice Sapinka very seriously. The human rights regime is the final refuge for the disadvantaged and the disenfranchised. Every victim in this case is entitled to your timely, considered analysis. And even though this case comes to you in the framework of First Nations reconciliation, which is to be celebrated and commended, ultimately, the Canadian Human Rights Act is about protecting the individual rights of these children and their families. The Canadian Human Rights Act is very clear about its purpose: to provide all individuals with the opportunity and the equal opportunity to have the lives that they wish for themselves. We will be asking you to consider 3 principles in your analysis. First, that you place children, as you always have, at the center of your consideration. We ask the tribunal, in examining the relief that is being sought, to apply a best interest of the child analysis, to make sure that all child victims in particular are considered, identified, and that the harm they have suffered that you have already found is part of your consideration. It is not the fault of any of the child victims identified by you in your rulings that the adults in charge of these 2 proceedings have made certain choices, and that is how we are here today. The second principle we will ask you to consider is that you must pay critical attention to the evidence about what it is telling us and how victims have suffered. In our view, if changes are to be made to the orders, they must be grounded in the evidence. Thirdly, we will be asking that you provide a very clear and well-articulated human rights analysis, considering the dialogic approach, how important it has been to this case, and whether or not what you see here today is a result of that dialogic approach. In our view, it is not. The Caring Society and other interested parties were not at the table, and we did not have the opportunity to come back to you, as we have many times before, when we could not agree. That critical nature of consultation and adjudication is what gives the tribunal its power and the power of the dialogic approach that, in our view, has made the orders possible. Now, before I turn to the legal arguments, I wanted to take a few moments to address some of the factual issues that came up yesterday in the submissions from my friends from the Assembly of First Nations and Canada. We absolutely agree with the AFN that victims have been waiting. They have not only been waiting for their compensation, but they have been waiting for long-term reform. Since the merits decision in 2016, the implementation of immediate relief as directed by this tribunal has been difficult, and we have had to push Canada at almost every turn to comply with the directions of this tribunal, that Canada immediately cease its discriminatory practices in relation to both Child and Family Services and Jordan's Principle. As this tribunal well knows, the fact that we have had to seek multiple non-compliance orders for immediate relief has ultimately delayed redressing the discrimination experienced on the ground. And victims have been waiting for compensation as well. The fact that the victims do not already have their human rights compensation is a direct result of Canada's refusal to acknowledge that this panel has the jurisdiction to order Canadian human rights compensation, or that the victims are entitled to unique and meaningful human rights compensation that has been ordered. I think it's important that we keep this in mind, that Canada's fundamental argument to the federal court and to this tribunal was that the tribunal does not have jurisdiction to order compensation. The delay now experienced in paying the compensation is not a result of steps taken by the Assembly of First Nations, the Caring Society, or any other interested party. It is the direct result of Canada's refusal to accept the tribunal's findings and move on. It sought judicial review and now is appealing the decision of the federal court. We agree with many of the important fundamental aspects in the final settlement agreement in relation to the process being First Nations led, trauma informed, and inclusive of critical supports that will be needed for the victims who access this process. Many of these important tenets of the final settlement agreement actually come from the compensation framework and were ordered by this tribunal in 2021. It's important to remember that the compensation framework is a direct result of the dialogic approach. This tribunal ordered the parties to work together to find a way to distribute compensation in line with your direction, and that's what we did. Between 2019 and 2021, the Assembly of First Nations and the Caring Society worked closely with Canada to develop an implementation strategy for distributing compensation to the victims in this case. When we could not agree, we came back to you. And as you know, you have made many orders between 2019 and 2021, making critical findings that safeguard the rights of the victims identified in this case. The compensation framework requires that beneficiaries be located in a culturally safe manner. It requires that the process be child-focused and easily accessible to those who are seeking compensation. This was agreed to by all three parties. It requires a proactive, highly publicized approach based on the circumstances and experiences of the victims of this case. The compensation framework also requires special measures necessary to inform beneficiaries with special and distinct needs, making sure that we take great care to reach children, people with disabilities, and even those who are incarcerated. These are all tenets of the compensation framework. And while we applaud their inclusion in the final settlement agreement, it's critical to understand that this is not an either-or situation. The compensation framework has critical supports and safeguards for victims. The compensation framework also provides critical supports for beneficiaries before, during, and after the compensation process unfolds. This was a key recommendation of the Youth in Care that we worked with throughout following the 2019 decision and throughout our work on the compensation framework. Youth in Care told us that it is going to be important that supports are there not just before, not just during, but also after they receive their compensation. We heard them, and that fundamental principle is included in the compensation framework. It also provides supports directly to First Nations, who will be able to support those within the communities who are accessing compensation. Everything from navigation services to other supports and financial support that First Nations may need in order to compensate victims. Under the compensation framework, these will be funded by Canada. They committed to that. And it will not be clawed back from the compensation that you have already ordered. We also took a trauma-informed approach to make sure that we protect beneficiaries when we deliver compensation to them as quickly as possible. It's also important to note that we too had the opportunity to build a First Nations-led process. We just never got that far. Because of Canada's judicial review, the parties never got to build the guide that would accompany the compensation framework, select a central administrator, or pick from 3 agreed upon trustees to manage and govern the distribution. Those chances were taken away by Canada's judicial review. But much like the final settlement agreement, the fees associated with the central administrator and the appointed trustee would also be covered by Canada to make sure that those victims receive their compensation in a culturally appropriate and safe manner. So the compensation framework is jam-packed, in our view, with significant supports and is built on an approach from lessons that we have learned in other processes, from discussions with the Assembly of First Nations, and making sure that we keep the victims at the center of our approach. Now, I agree that on the face of it, the final settlement agreement appears to be further along. But as I have said, we were never given the chance. We were never given the chance to build the guide, to put notices out, to do consultation, and to ensure that we delivered compensation as ordered by this tribunal in a child-focused and victim-centered manner. Now, many comments were made yesterday about the speed with which compensation can be delivered. We too, in the compensation framework process, were very acutely aware that victims are waiting. Under section 7.1 of the compensation framework, we made it very clear that our implementation would begin within 15 days of the framework being final, but it's still not final. Final in the compensation framework is defined as no longer being subject to judicial review or appeal. As you know, Canada has appealed Justice Favel's decision to the Federal Court of Appeal, and therefore our hands are tied and we cannot begin this important work. I'll just pause here to note the way that Canada has approached this process. As a term of the settlement agreement, Canada is requiring that there be no settlement unless the tribunal approves this agreement. This is clearly to the benefit of Canada only. Member Lustig, as you observed yesterday in your question to Mr. Vickery, Canada is seeking to manage its continued liability to avoid the prospect that someone who could conceivably receive a lesser benefit under the final settlement agreement could still seek to enforce the tribunal's compensation order. That requirement protects Canada. It does not protect victims. Canada could have chosen a different approach, such as an opt-out threshold for those opting out of the final settlement agreement, or it could have considered a term for coming back to the tribunal at the claim stage process or at a time when the evidence will be made clear about who is in or who is out. Opt-out thresholds have been used in other class actions involving First Nations victims, and Canada could have made a different choice. Such an approach would have given individual victims that you have already identified in this case the power to endorse or not, the power to say yes or no to the deal in a way that would give the choice to them, choosing human rights compensation or compensation under the final settlement agreement. In our view, Canada chose to put this poison pill in the final settlement agreement, requiring the tribunal to approve the settlement before it will pay the money. In our view, Canada is trying to get through the back door what it cannot get through the front door, and this is fundamentally unjust. Before I move into my submissions on jurisdiction, I want to make it absolutely clear that we agree with the comments from the AFN about the bold nature of this proceeding, about what has been accomplished on behalf of First Nations children and their families through the collective, tireless cooperation between the complainants, the Commission, and the interested parties. It should not be lost on any of us, including those watching today, that great things have been accomplished through this case. Without this human rights litigation, the changes made on the ground for service providers, navigators, those delivering Jordan's Principal services could never have been accomplished. It is important to remember that litigation is what resulted in change. We agree the tribunal has taken incredible steps to protect the victims in this case. But in our view, what you have actually done is affirm existing rights that belong to First Nations children and their families. You have brought these rights to life. Our justice system has not been kind to First Nations children and their families, and it has taken a very long time to entrench those rights within our human rights regime. The tribunal has now done that, and the federal court has upheld that. It is an incredible step that, in our view, cannot be undone. There are two fundamental things in our view that cannot be legally interfered with or interrupted on this motion. The rights that you have placed in the hands of First Nations children and their families should not and cannot be undone by an outside class action process. The orders that you have placed in the hands of the victims are twofold. First, the set of entitlements to $40,000 for each victim of this case. While we agree that it is something to be applauded that Canada is agreeing to settle victims' rights who are outside this process, your goal and your requirement is to the victims of this case. The entitlement of $40,000 to the victims that you have identified cannot be interfered with. Once you made your order, and once the federal court upheld those decisions, those rights are sitting in the hands of those victims. The second area that we say has been well articulated and cannot be legally interfered with is the eligibility criteria. These fundamental rights have now been entrenched. They have been acknowledged, and you have given voice and credibility and grounded them in the legal framework to which you follow, the Canadian Human Rights Act. You have gifted these rights to the victims, and those rights, as I said, have been squarely affirmed by the federal court. We can't take those back now. It would be fundamentally unjust to our legal system to put human rights compensation in the hands of a victim and then allow the wrongdoer, Canada, to take them away. So the Caring Society's objections to this motion has nothing to do with the good work done by the parties to the class action, or to the expansion of the class size, or to the expansion of the years of eligibility. In our view, there is likely no limit to the harm caused by Canada to First Nations children and their families. Our objection flows from the ability of Canada, the government which caused the harm found in this case, to absolve itself from having to compensate every victim identified in this case. That is our fundamental objection. So I will turn now to our first issue, which is that of jurisdiction. And I'm hopeful that I am as clear as I can be. I am concerned that some comments made yesterday by my friends from the AFN misunderstand what we are arguing with respect to jurisdiction. The issue is not whether or not the tribunal remains seized of certain aspects of compensation. We agree that it does, and I will take you to those provisions in the compensation framework. It is not about implementation. It is about final orders and how those final orders are considered and constructed within the. So as I mentioned, I would like to review some of the key principles that I think will be important to your analysis when you're considering this critical question. And it is a critical question. As you know from our material and from the material of the Human Rights Commission, if you do not have jurisdiction to grant the relief, that is the end of the analysis. And in our view, a very careful and purposeful consideration of this question must be undertaken. We agree with our friends from the Assembly of First Nations. There is no precedent to point to, and therefore we will be relying on your guidance and your analysis to the fundamental principles that you have engaged in this case so far. I would just point out that the Caring Society supports the submissions made by the Canadian Human Rights Commission found throughout their factum, but specifically paragraphs 33 through 62. The tribunal has made final orders with respect to entitlement and eligibility. Now, the case law tells us that a final decision means that all available means of review or appeal have been exhausted. Where a party chooses not to avail itself of those steps, the decision is final. And here we have a unique situation. We are before the Federal Court of Appeal, which begs the question, what exactly are you reviewing? In our view, the jurisdiction to question the entitlement and the ability to question the eligibility is firmly before the Federal Court of Appeal. Now, in general, a final decision cannot be revisited by an adjudicator who made that decision. This is a basic principle of administrative law, and I think no one would quarrel with that. It's a fundamental principle within our justice system because it provides predictability, reliability, and protects the integrity of the judicial system. Litigants are entitled to rely on the decision that has been delivered by the decision maker. And that means for better or for worse. As has been pointed out by the Commission in its written submissions, there are profound policy reasons as to why a decision maker, including a tribunal, cannot reopen final decisions. Certainly, certainty of outcome is very important. And when an administrative tribunal, like the Canadian Human Rights Tribunal, delivers a final decision on a specific issue, it then becomes functus. Now, this is where I'm concerned there's a misunderstanding. It does not become functus writ large. It becomes functus with respect to the specific orders that are final. And that is what is contributing to the complexity of this case. This tribunal has taken such an amazing and nuanced approach to dealing with the rights of victims. And so there are question marks that remain unanswered in our own process to which you retain jurisdiction. But there are other things that you have decided that are closed. Now, the Supreme Court tells us in Chandler and Alberta Association of Architects that as a general rule, once a tribunal has reached a final decision in respect of a matter that is before it, that decision cannot be revisited. And that is even where a tribunal has changed its mind or has made an error within its jurisdiction, or, as could be argued here, there has been a change in circumstance. We would not question the fact that there has been a change in circumstance since we were before you in 2019. A lot has happened. But when a situation like this arises, the case law tells us that the tribunal is functus. In other words, it no longer retains the jurisdiction or the power to open the decisions that are final. So the central question for you is whether or not the compensation orders are final to the degree that the identified victims and the quantum awarded cannot be reopened. We say that they are. In fact, in our view, this panel has been particularly careful and nuanced in its approach on the issue of finality, and has made clear in multiple areas where it has retained jurisdiction and where it has not finally determined that it is final. So, for example, in 2019 CHRT 39, the very decision that gave rise to the entitlement, while the tribunal was clear that the entitlement to compensation for the victims was final, the tribunal made sure that it was not making a final order with respect to next steps. You ordered us to consult and to come back on compensation distribution. At no time did the tribunal in your decision anywhere say, if you don't agree that the victims are entitled to $40,000, please come back to us. That is essentially what is being requested of you now. In our view, you cannot do that. And I'll take you specifically for your bench briefs to paragraph 269 of CHRT 39. The tribunal said, there is also a need to establish an independent process for distributing the compensation to the victims and the survivors. The AFN and the Caring Society have both expressed an interest to assist in that regard. Therefore, Canada shall enter into discussions with the AFN and the Caring Society on this issue. The Commission and the interested parties should be consulted in the process. However, they are not ordered to participate if they decide not to. And here is an important line for you. The panel is not making a final determination on the process. On the process. You were not making a final determination on the process. Rather, it will allow the parties to discuss possible options and return to the tribunal with propositions, if any, no later than December 10th, 2019. The panel will then consider those propositions and make a determination on the appropriate process to locate victim survivors and to distribute the compensation. So your direction to the parties, in our view, was crystal clear. You had made final orders that the victims in this case were entitled to $40,000. What you had not yet determined and what you left the door open for was how was that money going to be distributed? And on that point, You left that door open until, in our view, you closed it in 2021. Now, at paragraph 17 of the 2021 decision, 2021 CHRT 7, you made clear that the parties themselves understood that they had come to a final order. At paragraph 17, the tribunal wrote, the tribunal initially conveyed its determination in 2021 CHRT 6 by way of a brief letter, the written equivalent of an oral ruling with reasons to follow. Subsequent to the letter and prior to the release of 2016 CHRT 6, the parties negotiated the final version of the draft compensation framework, which has now been submitted to the tribunal for a final ruling. We all understood when we came before you with our compensation framework that we were seeking final, legally enforceable, entrenched orders that would protect and safeguard the rights of the victims. And that's exactly what CHRT 39 and CHRT 7, that's what they are. They are final rulings on the issue of entitlement and eligibility. Entitlement and eligibility for the victims of this case, who you have found are entitled to human rights compensation. Compensation for the infringement of their dignity, compensation for the harm they have suffered as a result of the discrimination examined and found in this case. And for us, it's clear that the specific reasons given by the federal court amplify the fact that these are final orders. It's trite law to say that you can seek judicial review of an interim decision. We all know the very well-known case of C.B. Powell, the Federal Court of Appeal case from 2010, that makes it very clear that absent exceptional circumstances, you cannot go to the federal court to seek judicial review of an interim decision. In our view, the federal court never would have entertained Canada's judicial review if they were not final orders. Now, the cases cited by my friend from the AFN in reply, in our respectful submission, don't help deal with this question. Those cases focus on the jurisdiction of the commission, something that is very different but important and has very different considerations. In the cases referenced by my friends yesterday, this was about, the cases that are in the reply talk about whether or not there can be a reconsideration by the commission of decisions to dismiss complaints. Those considerations do not make their way into the analysis before you. All of the cases referenced by my friends involve the commission and not the tribunal. That process is less formal and involves an investigation, not a traditional adversarial process. Similarly, the Simtron case, which is a decision of the Canadian International Trade Tribunal, does talk about the principle of flexibility in relation to the functus doctrine, where that tribunal was allowed to consider a new complaint. But that was to accommodate the more vulnerable party and grant more procedural fairness to the party who would lose out. That's not the case here. In our view, the flexibility doctrine should not be exercised in a way that absolves Canada's liability to compensate victims in this case. I think I've made this point already, but I have a sticky and I want to make sure that it's clear. We really feel like it's important that the tribunal really understand that the only thing that has stopped the payment of compensation in this case is Canada. Canada's judicial review and then its appeal. It always had the opportunity to acknowledge the harm that you acknowledged in your decisions and to pay the money that you ordered them to pay. They chose not to do that. Now, we agree with the AFN and with the tribunal that you do have retained jurisdiction over some implementation of the compensation framework. You have, in fact, retained and carved out for yourselves, we would say, something that is very innovative, flexible, and creative. And we put that to the federal court as well when we were there, about how you even got to the point that we had gotten to. So I want to be clear, the Caring Society is in no way suggesting that the tribunal does not have retained jurisdiction over some elements of implementation related to compensation. It's our view, as supported by the case of Grover, that you can give life to the remedies that you have ordered. And the federal court makes that clear at paragraph 32 of Canada versus Grover. I keep saying make it clear because it's very important that we really put these issues at the center. But here, the federal court also makes it clear. It says, it is clear that the act compels the award of effective remedies, and therefore, in certain circumstances, the tribunal must be given the ability to ensure that their remedial orders are effectively implemented. In other words, the tribunal can retain jurisdiction to ensure that the remedies ordered by it are effective and forthcoming. And when you look at the facts of Grover, you can see exactly what the federal court is talking about. That was a case where the complainant was seeking redress with respect to employment discrimination. He had, in fact, the tribunal had found that he had been racially discriminated within his place of employment, and as one of its remedies, ordered that he be appointed to what they coined an appropriate position to the National Research Council. Now, the tribunal did not give much guidance on what it meant by the term appropriate position. And so ultimately, the complainant had to go back to the tribunal and seek clarification once he was given a new position. He was given a new position, and in his view, it was not appropriate. And so the tribunal clarified its orders and went on to make very clear direction, give very clear direction about what it called an appropriate position. But it was not open to the employer, in our view, in that context, to say he's not entitled to an appropriate position. That is where the distinction is, and that is the analysis that the Caring Society is asking that you consider. You can make implementation orders in relation to compensation. You cannot now say some kids and some adults are not entitled to compensation. That is what Grover tells us. You have this unique and flexible ability to stay involved in the implementation of the orders that you have made. The Caring Society agrees with that. We welcome that. We know we need you to finish the job. But what Grover tells us is that it is not open to you or to a respondent to come back and challenge the very order upon which the remedy must be implemented. So that is what we have to be mindful of. The tribunal can give direction, it can refine and make clear what it meant by what it said. That is what you can do within relation to compensation. But the selection of the, Member Lester, are you asking a question? You're on mute. I'm so sorry, sir. You're still on mute, so I can't hear you.
Sorry about that. Do you hear me now?
I can hear you now.
Okay. So sorry to interrupt you. It was important to me to kind of ask you about this as you're sort of saying it. So you seem to be distinguishing between the right of the tribunal to be flexible in implementation with respect to an order, as opposed to flexibility in terms of the order itself. That's what I take from you.
Absolutely correct.
Okay,
yes.
But you acknowledge, I would imagine, that there are situations like clerical errors, that kind of thing, that have been cited, where obviously the need is to clarify, and you can understand that that would be an exception to the rule, so to speak.
Absolutely.
So those kinds of things. So in a case where you have a unique set of circumstances, entirely unique, we're here because we thought we were at the max of what we could grant, given the circumstances. But this agreement that now includes people who weren't part of our case, were in the class action, going back to 1991 are going to be entitled under the FSA to benefits that, frankly, if we had had the opportunity to do so, we would have, because our case, the complaint started in 2007, so we were restricted by that date. But that agreement now is part of this, because the government has decided in its wisdom that they want to settle everything at once. They want to get this finished. And so we have a unique situation, totally unique, where we are being asked to make a decision with respect to an agreement that incorporates the needs of classes of people that obviously our decision on liability also applies to. These are people that were the victims of discrimination. And we have the opportunity to consider this agreement. But you're saying, I mean, it's being put to us that we have the opportunity to consider this agreement now, or face some fairly negative consequences to a lot of people if we don't. And you're saying we don't have the right, and there isn't a flexibility in Human Rights Act in jurisprudence to be able to open the door and say, wait a minute here, what are the risks here if we decide not to do this? And we really, in a position where we can balance all of this and take up those risks if they're true, if we end up with a situation where the litigation continues and these benefits are lost. And so there's a balancing there. And if there was flexibility in terms of our rights to look at it in the context of, what's needed in order to allow it to proceed, it would be something that would be very, very important, it would seem to me. If forgetting about, any of the adversarial aspects of this, just to get down to the bottom line, which is to help children and to help victims in particular in this exercise, what's the best we can do? What is the very best that we can do?
And I think that you, Member Lustig, are actually in one question sort of bringing together the enormous challenge that this case, $20 billion going back to 1991. I mean, the Caring Society, when I say at the outset that we acknowledge how critical this is, we really do. And I really appreciate your comments by really understanding the enormity and the context of what you're being asked to do. The difficulty is that a couple of things. The risks and the consequences that are being put to you are challenging because in many respects, they're non-legal risks. So I appreciate that this case, and frankly, one of the strengths of this case is that it hasn't just been about whether or not kids do or do not have rights. I mean, this case has fundamentally, in our view, shaped the conversation in Canada about what kids are entitled to, whether they are First Nations or not. So I appreciate the enormity of what you're being asked to do. I think the challenge is that you're being asked to rescind, in some respects, some of the rights that you have given. And you haven't given them, you've affirmed them, really. In our view, these are rights that are legally entrenched. If the final settlement agreement, for example, made guarantees that all removed children from their home, families, and communities were entitled to a minimum of $40,000. If the estates of deceased parents were guaranteed $40,000, and if the parents and the Jordan's principal kids had certainty about the orders that you have already made, you could tick the box and this could be done, in our view. Because that approval, even though there are things in the final settlement agreement, for example, about who the central administrator is, how compensation claims are going to be administered, these are, in our view, the things that have been left open, where you could say, you know what, we are going to look at the final settlement agreement, and even though their claims process does not have a first reviewer and a second reviewer, as it does in the compensation framework, we can take a flexible approach. That, to me, is the issue. It is not about whether or not you can fundamentally say yes or no to the final settlement agreement. That's not really the question. And in our view, this is the struggle or the concern with how this has all unfolded. You're being asked to look the other way, so to speak, not in a mean way, not in a negative way, but you are being asked to say that for the greater good, if I can put it that way, we are going to say that some of the victims that we recognized will not be entitled to $40,000. In our view, that is what cannot be done in law, notwithstanding all of the amazing reasons that you might want to do that. And I really acknowledge that this is a historic settlement, and it is very tempting to do that for what we would consider the greater good. But to that one child who has seen their rights written in black and white by you and by the federal court, that they are entitled to $40,000. In our view, that is the right that cannot be interrupted. How it goes out the door, when it goes out the door, who gives it to them, who helps them fill out the form, what supports they're entitled to, when they're entitled to these supports. This is the flexibility that you can bring to this process. That's what I'm trying to show, is that there is a difference.
Okay, so you've said that flexibility would apply to the implementation process. You've said that flexibility wouldn't apply to the order of compensation part, but that if there were some clerical errors and other things like that that have been cited by the other side, those would be exemptions. Those are reasonable. But then you just said, if we were to endorse, this is what I took from what you said. If we were to endorse the order, but do so and sort of bring back the people that are going to perhaps lose out as a result of the FSA, that would be okay. That I think you said we could do that.
Well, that wouldn't be an interruption of your order, in our view, right? If you were to affirm the rights that have already been won, of course, that is open to you. And in our view, that's what you should do. I think what you should do on this motion is say, look, guys, you've got kids, you've got estates, you've got Jordan's principal claimants. We've made our orders. Now, we're prepared to work with you on implementation. And what I think would have to happen is we would have to look at the compensation framework together. So, I was just going to go through the compensation framework with you to show that AFN Canada and the Caring Society, of course, anticipated that we were going to need to do more work. And in fact, we very purposefully, I would say, with your assistance and your guidance, left the door open on certain questions of implementation.
Sorry, I just want to go just back to finish this part about the jurisdiction and when and if we have flexibility. So I put to you, if we were to put back, so to speak, in our endorsement declaration, what has been removed. I'm using those words loosely, but you know what I mean.
Yes.
That would be okay. What about if so this is the final part of what I'm going to ask you, and I'll leave you alone after this.
No, this is important. This is important that we have this discussion.
Okay. So what if there were one of those things that were put back? I'm not saying that's what we're thinking at all. Okay. Right. I'm just putting this to you because I want to know the parameters of what you think is flexibility. And so what if, let's say there were 4 things that were either reduced or eliminated. I think there are actually, according to you.
Yes.
So let's say we put one of them back because we just thought rationally, this could be done, it should be done. This is kind of what we had always thought would be done, that kind of thing. And we said this is more in keeping with the order that we made. But to use your words, for the good of most, on balance, nothing being perfect, we can't let this thing just drop, and we can't let it. That's not what the tribunal, is about. And so we have to be very wary. I'm not saying that that's exactly what's going to happen, but you can imagine that's what's going through our minds. So,
Of course.
so you know, I'm interested in knowing about this flexibility. That's what.
Yeah, no, and I really appreciate your questions, Member Lustig, because I think it really drives at the heart of what's at stake, to be quite honest. And I think, you know, the four things that the main four things that we've identified in our view, where the final settlement agreement departs from your orders, are where you have affirmed rights. I mean, people have their arms wrapped around your orders that say, holy cow, I was a child removed from my home, family, and community. I don't know where I was placed, who paid for my placement, but I was removed and I have that right. I am recognized by this system that is entrenched in the Canadian framework, by the way. I have a right to have my infringement of dignity recognized. And that goes for, and that to me, right? And so the difficulty, I think, not to interrupt you, but the difficulty becomes, you know, what do you do about those kids who have had their rights affirmed? So what we would say is our first submission to you would be, you cannot take those rights away. Now, our second submission is that if the tribunal is of the view that it has the legal pathway to walk back some of those rights, then we would say you have to apply a human rights approach so that we are not starting to allow class action considerations to integrate into the human rights process. If you can find a way to do that, and when I get to like page 47 of my submissions, I hope I can set that out for you. But that is what we would say. We would say, of course, at first instance, you can't retract rights that have been acknowledged. I mean, that within our system would be so fundamentally problematic, particularly for a vulnerable community like First Nations kids and their families. However, if there are other considerations that you feel would require you to deviate, then you have to use a human rights framework to get there. In our view, you know, is it fair and reasonable? Is it balanced? Were the trade-offs fair and reasonable? I mean, this is a class actions approach. This is the very test that will be applied next week at the federal settlement approval hearing. And that is a very important process, but the legal tests that are applied in the federal court do not necessarily, in our view, integrate well with the human rights framework. There has to be, in our view, protection of this system that has given so much to the victims in this case. I hope that kind of answers your question.
I'm sure that, well, it's been very, very helpful to have this discussion with you, and I appreciate your answers. Yes, thank you.
Thank you. So I will point you now to, in our view, the key areas where there is flexibility, where there can be ingenuity and creativity and innovation around what can and cannot be approved with respect to the final settlement agreement. And in fact, in the compensation framework, the parties identified three key areas where the tribunal ought to retain jurisdiction. And the first is in section 9.3 of the compensation framework, which reads that all claims will initially be reviewed by a trained and duly qualified first-level reviewer according to the service standards agreed to by the parties and approved by the tribunal. So what we did in the compensation framework was we considered how claims would be approved, but we left ultimately the door open to the tribunal on exactly how, you know, that process would unfold. That was a place where at the time that we prepared the compensation framework, we felt you needed to retain jurisdiction to make sure that the way that these reviews were being done would actually accord with the guidance that you had provided in your decisions. The second place where we asked that you retain your jurisdiction was in section 9.6. Which reads, potential beneficiaries denied compensation can request that the second level review committee reconsider the decision if new information is relevant. It goes on to talk about appeals, and an appeals body And we stated that the appeals body will be a non-political and independent of the federal public service. And I would say this was a place we never got to, where we could have incorporated a First Nations-led approach, but we were never given that chance. Section 9.6 goes on to say the parties agree that decisions of the appeal body may be subject to further review by the tribunal. And so we wanted to provide safeguards to victims as they went through an appeals process. And this, Member Lustig, I think section 13.1 is really what you're getting at, and where we would say the greatest flexibility would come with respect to implementation of those rights that you have already determined. The framework says that it is intended to provide general guidance to facilitate the compensation process. As noted, the parties will continue to work on tools that may provide more precision to guide the implementation of the framework. Processes can and should be amended where the parties agree amendment is necessary. Such amendment will not require the approval of the tribunal. And here's where you come in. If the parties disagree on the necessity of an amendment or the wording of an amendment, the tribunal shall determine the issue on motion from the party requesting the amendment. So there was always a view that if we couldn't figure out the distribution, if we couldn't figure out how to do it, or what the parameters would be, or the timelines, or the notices, or things like that, that you would assist us. And that is where that flexibility comes with the cross-pollination, in our view, of the final settlement agreement, that these questions of implementation do remain open to you for your consideration. And so we agree that the panel retained jurisdiction on these issues. So you retain jurisdiction to deal with disputes about, interpretation and the application of the compensation framework. And that means that you could help us if we got there. But we're not there. That's the problem. You're being asked to revisit orders that have given rights to victims. Entrenched rights that have been recognized by the federal court, and how you circumvent that process of finality with those rights, particularly given what's at stake, in our view, is simply not possible. It is not grounded in legal analysis. It is grounded in other considerations. And for the integrity of the human rights process, for the rights of victims who have seen, that their entitlements printed in black and white, we cannot circumvent that process. Only the Federal Court of Appeal can tell us that we were wrong about who is entitled and how much money they're entitled to. So that's really where it comes down to. And in our respectful view, the orders and the rights that have been acknowledged can't now be interrupted. The retention of your jurisdiction was always about implementation. It was about helping the victims identified in the case receive the compensation pursuant to the framework and pursuant to clear and specific orders that you have made regarding who is a First Nations child, things like the definition of delay, what is the definition of essential service, and how should money ultimately be paid to victims. Those things have been decided in our view, and they can't be reopened. So in our view, and as shared by the commission, reopening final orders like the ones made in this case, is potentially dangerous. And it puts vulnerable claimants in precarious situations. And that's where, go ahead.
I was just thinking about your comment about not disturbing rights that were given, as in not reducing to a potential claimant the amount that they would have got. But the same argument could be made on the other side, couldn't it? That you're saying that we couldn't condone in some fashion, confirming the FSA, for example, or condoning it, or endorsing it, I should say. We couldn't endorse the extra payments over $40,000 for people who are going to benefit, if I follow your reasoning, because that would mean we made for a $40,000 decision, and that's it. And even though a lot of people may end up with a lot more than $40,000, too bad. That's it. Does that strike you as being completely reasonable, given the circumstances?
So if I understand your question, are you asking me whether or not the tribunal can endorse as a matter of law more than $40,000 for the victims?
I'm asking you whether or not there's sufficient flexibility to allow for this to happen. That's really my question.
So I think this is where the cross-pollinations of the two proceedings is really important to think about. In our view, and it has always been the Caring Society's position, that the orders are the floor, right? So your orders can be respected within the class action process if the 40 is the floor for the victims that you have identified. And because Canada has made it a term of the final settlement agreement that you approve the settlement, in our view, you would not be exceeding your jurisdiction to say, we approve, if the orders are baked into the final settlement agreement, because then your orders are respected. And the federal court would not be endorsing a human rights determination about $100,000 to some or $80,000 to others. What you would be doing is saying, we, in our creative and flexible approach, will agree that it's going to be distributed in a different way, because it will be certainly distributed in a different way in the class action process. But our fundamental orders that kids, families, estates get $40,000. These are the parameters on Jordan's principle that we've already ordered and have been upheld. So we're prepared to hand over the implementation of the compensation to the federal court. That in our view is open. There is flexibility baked into that. Now, whether or not they do it in a proper way, I would say, you might want to be a part of that. You might want reporting back. You might want the Caring Society and the Commission and others to be a part of that dialogic approach to ultimately safeguard the rights of the victims that you have identified. But just on a pure question of jurisdiction, I don't think that you would be exceeding your jurisdiction by approving a settlement that uses your orders as the floor. There may be other important considerations about how that ultimately gets done, but on a pure question of law on your jurisdiction, in our view, you would not be exceeding or retrenching or not retrenching, but infringing on your own jurisdiction or the jurisdiction under the Canadian Human Rights Act, if the final settlement agreement on these two particular points were reflected there.
Okay, thank you.
I mean, it's very complicated. And this is, can you imagine if you're a victim trying to understand what's going on here? I mean, this is part of our concerns, and you can see that in the evidence. It's extremely complicated. It's very, very hard to know exactly what, how to understand what is happening. And I just think that that's an important consideration when we're thinking about the timing and how this is unfolding. Just how are victims to understand what is happening, given even just this conversation that we're having. And so, we do think that it's important to really think about the precedent that could be set by a human rights tribunal taking rights from a victim, an individual victim, which is what the Human Rights Act is there to protect, and putting them in the hands of someone else. I mean, that is essentially what you're being asked to do, in our view, is to take hard-fought victories from some and place them in the hands of others. And while there may be an altruistic desire to do that, in our view, the human rights framework does not allow for that. There's good reason for that. These victims are entitled to compensation, and they're entitled to receive it within the parameters of the legislation and the orders. And so it's concerning to the Caring Society that this case could come to stand for the proposition that victims who have had their rights vindicated by the tribunal and upheld by the federal court could have those rights erased or reduced because of other outside considerations. I mean, that is the fear. And, the context should not be lost on us. This is the first systemic case since Section 67 was repealed. And so to have a case involving First Nations children, having that be the precedent where rights can be taken from them and given to others, could set a very dangerous precedent and could, in our view, augment the rights of First Nations children and their parents in a way that does not enhance the rights going forward. And at the very least, makes it very unclear what those rights actually are. And I think I would put to you, Member Lustig, how do we answer that question? What are we saying? What do we mean in law, not in the outside considerations, the political considerations, the press, the drama, the $20 billion, but for that one child, what are we saying? If we can take $40,000 from that child and give it to someone else, what does that mean in law? And I think that question has to be squarely answered when we consider the question of jurisdiction. How can you give something to one victim and then take it away and give it to someone else? In our view, only the Federal Court of Appeal can do that. That is a critical question of jurisdiction, and it must be answered on this motion. It is a critical threshold preliminary issue that if we do not understand the answer to, we are concerned that it will set a very dangerous precedent. So, this is the issue. We have this problem of jurisdiction, and I would say respectfully that those two critical pieces, the entitlement to the 40 and the eligibility criteria, cannot be interrupted. And it is only on implementation that you can use your creative tools to help guide the process. So I've sort of ended my discussion on jurisdiction. I've been talking for 1 hour and 15 minutes, which always flies by. I don't know if people want to take a break. Otherwise, I'm happy to continue.
Well, please continue for a little bit.
Sure. Okay. Okay. So,
Ms. Clark, I'm sorry. Yes. Will you get into, because there seems to be contention around who are the children that are entitled to 40,000 compensation. I think this is a crucial question.
Yes.
You heard your friends yesterday, and they'll have an opportunity to respond. It's crucial that this is addressed before they provide the reply. So will you be getting into this?
Absolutely. Absolutely. Okay. I'm actually going to go there now and talk a little bit about the key departures that we see in the final settlement agreement compared to what's been ordered by the tribunal. And obviously for us at the Caring Society, the kids are the critical piece. Children are so critical to this case. They have been the voice of this case throughout this proceeding. They've come to the proceedings. I know some of them are watching today. And it's just really important that we get to the children. So let me then go there now, Chairperson Marshall Dawn, about the key departures that we see between the final settlement agreement and the compensation orders. So I would just say at the outset that I think our friends yesterday, agreed, for better or for worse, with the different interpretations that will ultimately be determined by you, but this is not a mirror image. There's absolutely, I hope, from what I heard yesterday, there's no dispute that the final settlement agreement does not mirror the orders that you have made on compensation. That's not disputed. What is disputed, of course, is what that all means. And I will start with the children. So there are two fundamental departures from the tribunal orders that, in our view, cannot be remedied by implementation. No matter how the final settlement agreement is implemented, these departures cannot be remedied. And the first, of course, Member Marshall Dawn, is the children. So I'm going to start with what can be termed as the non-ISC funded children, or I will call it simply kids who are in placements that are not federally funded. And I think that if I understood my friends from the AFN yesterday, and I apologize if we're not clear in our material, I think they misunderstand our concern. The issue is not whether or not children are in care or not in care. That has never been, the definition of in care has never actually been determined by the tribunal, much like the experience we had with First Nations child. This, as we will recall, throughout the decisions leading up to 2016 and even those into 2018, that term had never been defined, and everyone, as clearly came out in the evidence and the submissions, had a different view about what that meant. In our view, whether or not someone is federally funded or not is a separate issue that has not come before you specifically on this question. And in our view, that's because it's unnecessary. The discrimination in this case, the bedrock of the discrimination is not whether or not a child was in a federally funded placement. The issue is the removal. So the Caring Society fundamentally disagrees with our friends from the AFN and the government on this particular point. And I say this as with respect and with consideration. It is fundamentally important when we're dealing with issues of reconciliation that we be open and honest with our friends. And that is what the Caring Society is doing. Now, as I understand their argument, it's their view that the compensation entitlement orders restricted eligibility to children who were in ISC-funded placements. And we see that in the answers to cross-examination and in the material as well. In our view, the interpretation of the 2019 order and all of the orders that followed is correct, that the issue is removal. And that's because the removal is tethered to the findings of the tribunal made in 2016 and all the subsequent decisions that flowed from that. This case was never about which home a child went to when they were removed. The case was never about whether a child went to a foster home or a group home or a secure treatment facility or placed with a family friend. This case was about why. Why was a child unnecessarily brought into the system? Why was a social worker going to the door and telling a parent that the child has to go? Why was the social worker using removal as a child welfare tool to keep kids safe? Now, the answer was never as simple as the government is now suggesting. In fact, that's the problem. The complexity of this case is not about whether or not a child was or was not placed in federal care. The question was always why. Why is the child coming into contact with the child welfare system with removal as the first protective measure that could be taken? Why were culturally appropriate preventative services and least disruptive measures that keep kids safe at home inaccessible to First Nations children and their families? And you answered that question because Canada was racially discriminating against those children. That's why. It's not because they were placed in federal state care. It is because they never had the opportunity that other Canadian children had to have those preventative services and least disruptive measures made accessible to them. And the evidence was overwhelmingly clear on this point, from NPR to Wande to the federal government's own website. They were not providing access to protection workers and prevention workers to deliver services that were mandated by the legislation. And I'll just point to, Wande talks about this, and this is in the record. Wande says agencies could not effectively provide preventative services. They effectively had no money to comply with the statutory requirements to provide families with a meaningful opportunity to redress the risk that resulted in their child being removed. And that's from Wande, Coming into the Light of Day, 2005, page 21. That's what the case was always about. It was about the nexus between the legislative mandate of child and family services agencies, which the federal government required the agencies to follow, and the delivery of the services that they were required to meet under law. Child protection legislation across the country does not allow a protection agency to remove a child from the home unless they have tried everything else to keep that child safely at home. Removal is always the last stop on the train. It's always supposed to be the order of last result. You're not supposed to take kids out unless you absolutely have to. The risk has to be so significant that it cannot be mediated or redressed or in any other way examined by prevention services, least disruptive measures. Anything you can do to keep that child in the home should be done. And the discrimination in this case came from the willful and reckless underfunding by the federal government to deny kids that opportunity. That is where the discrimination always sat. Why weren't First Nations kids given the opportunity under law to have access to those prevention services? Why couldn't they put mom in a treatment program? Why couldn't they provide respite care services? Why couldn't they put kids in an after-school care program? Because they refused to fund it. And so the only way that a social worker could provide any relief was to remove that child. This is the nexus between the discrimination and the preventative services. This is what the tribunal talks about in its decision. And it's that removal that is the source of the harm. So this is where we fundamentally disagree with our friends. You always understood this. Questions were asked during the hearing about how is it that the federal government refused to provide preventative services in order to give these kids and family a chance to stay together. Now, this discrimination in our respectful submission is absolutely exacerbated by the fact that the federal government would pay 100 cents on the dollar for placements that it paid for. So it would pay an agency 100 cents on the dollar for maintenance costs, which, by the way, it still does. And that absolutely incentivized protection workers to remove. And you found that in your 2016 decision. But the discrimination is not because Canada paid for maintenance. That's not the discrimination. The source of the discrimination is the fact that kids never got the chance to stay home. Why? Because they're First Nations kids. That's the only reason. Because the federal government decided that First Nations kids, in our view, were not worth the money. They were not going to give agencies access to prevention dollars. And the record is very, very clear on that. Instead, the federal government willingly and knowingly underfunded preventative services, which drove kids into the system in an unfair and completely discriminatory manner. And of course, I've said, and I think we would all agree, that this discrimination was then exacerbated by the state funding of federal care. But the placement itself is not determinative of the discrimination. It was the fact that these kids just didn't have a chance, and the government knew what it was doing. Now, I think it's important that we really think about this issue, and you can probably tell from my impassioned submissions that the Caring Society feels very strongly about this issue. No child should be left behind by this decision. Not one child that you have recognized in your decisions should be left out. And I think that this is made all the more clear by your very recent decision of March 24th, 2022. You made a number of consent orders that have, of course, improved the lives of First Nations children across the country, and two of which are profoundly important to the issues that are before you today. The first is that the parties agreed to an end date of discrimination of March 31, 2022. The second is that the parties amended the 2018 actuals order to supplement prevention from being provided at actuals to be provided at $2,500 per capita based on First Nations-led research, an evidence-informed approach to changing the way we deliver child and family services. The nexus between the provision of preventative services and the end date for compensation is critical. The tribunal closely reviewed the evidence put forward by the AFN and the Caring Society on these particular points and agreed that prevention must address the structural and systemic drivers of First Nations children higher rates involvement with child and family services. As put forward in the affidavit of Stephanie Wellman from the AFN, and I'm quoting from paragraph 110 of the decision, prevention must encompass the systemic drivers that bring First Nations children into the overrepresentation of child and family services. Systemic change must also recognize the colonization of First Nations as a fundamental, underlying health, social, and economic determinant. And the panel goes on to say, we completely agree, and this corroborates the evidence in this case and is in line with the panel's findings on the merits and 2018 CHRT 4. So in our view, the parties never would have agreed to an end date. And more importantly, we would say, you would never have agreed to an end date if you were not satisfied that the worst case scenario of the discrimination had been addressed. Now, while you were not prepared to make a finding that all of the discrimination had been eradicated as a result of these consent orders, you were prepared to make a finding that the compensation end date would be March 31, 2022. And I just want to spend 3 minutes really looking at what you said, because for the kids who are watching, the survivors who are watching, and victims who may be impacted by this, your words in the recent decision this year are very important. The panel agrees, and you start at paragraph 144. The panel agrees with the parties that the consent orders in this ruling will ensure the unnecessary removal of First Nations children from their homes, families, and communities as a result of the discrimination found in this case will cease, given the implementation date of April 1, 2022. Since the beginning of the merits decision and onward, the panel has focused its orders on an adequate needs-based, culturally appropriate services as sufficient funding informed by the evidence. The panel has always emphasized a paramount need to stop removals of children from their homes, families, and communities. When removals were necessary, the panel stressed the importance of keeping kids in their communities and nations. The panel previously found that removing children from their homes, families, and communities and nations destroys the nation's social fabric, leading to immense consequences, and this is the opposite of building nations. The panel also previously found that the lack of prevention perpetuates the historical disadvantage and the legacy of residential schools already explained in the merits decision and rulings. It incentivizes the removal of children rather than assisting communities stay together. In our respectful submission, this panel, knowing what it knows and the work that you have done, would never have ordered an end date of compensation if the nexus between the harm and the discrimination was not sufficiently clear. It's the lack of prevention. It's the lack of prevention services that the actuals order addressed in 2018, and that the parties then worked together through a dialogic approach to come to you this year with the consent orders. Maintenance costs funded by the federal government are still covered at actuals. So ISK-funded placements are still covered at actuals, 100 cents on the dollar. Until we fix that part of the funding, that remains. But we've now done something critical with prevention. We've changed the way preventative services are delivered. We've given access to First Nations and First Nations agencies to deliver prevention in a new and different way. We don't have a request-based system anymore that we had in the 2018 actuals decision. So we know that the nexus of the discrimination and the worst case scenario that you found has been addressed in one important and critical way. We have changed the way prevention works. And on that basis, this tribunal ordered an end date on compensation. The discrimination in this case never started or stopped with who funded a child's placement. It started with the removal. And in our view, the tribunal always understood that. Because from the perspective of a child, whether or not you're sleeping in a bed tonight paid for by the federal government doesn't matter. The child was removed because the services that were paid for by the federal government did not include prevention services, services that were available to all other Canadian children. And that is why the tribunal found that these children have experienced the worst kind of discrimination and are entitled to compensation. Your 2019 order was very clear. It was very specific. It ordered compensation to all First Nations children removed from their home, families, and communities. It did not say compensation should only go to those who were in federally funded placements. You understood the landscape, you understood the evidence, and you knew what was at stake. And in our view, you would have made an order to that degree if the evidence would have supported it. But the evidence does not support that delineation or that distinction. In our view, children who were unnecessarily removed were victims of Canada's willful and reckless discrimination. And the tribunal found this. They should be entitled to compensation. And in our respectful submission, they are entitled to compensation. And we should not condone now, at this late stage, the restrictions on the rights of these children who have already suffered. In our view, you were very careful in 2019. At paragraphs 148 and 149 of your 2019 decision, along with your operative provisions at paragraphs 245 and 248, you were very clear that children who were removed from their home, family, and community are entitled to $40,000.
Can I just ask you a question?
Yes.
So this difference in understanding, shall we say, of what was intended by the tribunal, this has obviously become an issue. And what we heard from the other side, or in the brief of the other side, was that what you're saying on this issue is new, that this is sort of an added class that hadn't been contemplated before. And you say, obviously, that no, it's not. It's part of what was always decided. So I'm just curious, did you engage, or did the Caring Society engage with AFN and Canada and the Class Action Council on this issue? Because it almost seems a little strange to me that something is being missed one way or the other. Did you raise this when you first became aware in June, I think, of what the draft said? Were there some discussions? Because this is a pretty fundamental difference of opinion. And if you can answer this question too, or have they already answered your concern by saying that they can't identify them because they're not within their control? And so it will take some time and effort to be able to identify who those people are. But if they are able to identify them, is it your view that they're saying that even in that case, there wouldn't be money available to provide for the victims in a similar way to had they been documented and therefore recognized? Are they not saying that?
So let me preface my comments by saying there are things that are protected by settlement privilege. And in the unfolding of this motion, we have been skating a little close to the line. So I want to be really careful about what I say, about what is in the record and what is not in the record. What is in the record is an email from Mr. Taylor to counsel for the AFN and what we affectionately call the Mushoom team about this concern. So we raised the concern on April 22nd, 2022. And this email is attached to the answers for cross-examination of Dr. Blackstock, where we noted a concern that the compensation under the final settlement agreement departs from the compensation framework with respect to federally funded kids. So yes, we did raise it. And in our view, we were clear that our interpretation of the compensation framework includes these children. And I would just point to, and of course now I can't find, oh no, here it is, the compensation framework itself. And in our respectful submission, we were exceptionally careful about how we define these kids. And this is at section 4.2.1 of the compensation framework, where we talked about alternative care, including, any removal pursuant to the legislation, but not limited to kinship and various custody arrangements entered into between an authorized child and family service official and a parent or a grandparent. So in our view, we were very careful. Why were we so careful? Well, because when you work in child protection, the tools that you have at your disposal are not as rigorous, perhaps, as as is being suggested. When you come into contact with a family, the legislation, no matter where you are in the country, gives you options. It gives you options about how to help. And in every jurisdiction, there are voluntary arrangements that can be made between a child and family service agency and a family when there is risk in the home. And so we were very careful that it's not, and the reason we were very careful is because, and I should finish my thought before I start moving to the next, the reason that we were careful is because sometimes what happens, and this was in the evidence in the main, they're using removal as a child protection tool. The evidence was not every time a social worker uses removal as a protection tool, it leads to a federally funded foster care placement. That's not what the evidence was. It was about the removal itself as the tool for protection. And so we wanted to make sure that kids who were removed because they didn't have access to prevention were also compensated. And in our view, what you said in 2016 and onwards supported that. So yes, we raised that concern when back in April of 2022. I think if I understand their position on this, it's twofold. On the one hand, they say these kids were never eligible, even under the compensation framework. And number two, I think what they're saying is, even if they are eligible, there's no data to support it. And so in our process, we would like to keep them out because we can't, it's going to be too hard to find them. And we don't agree with that. So first of all, I would just say that even in the record that's before you, there is evidence about these kids. In Exhibit J to Ms. Savaglia's affidavit, we have this very, very important report that was done by Nico Trocme and Peter Gorham that actually builds on the work that was done that we solicited for implementation of CHRT 39. And there's a chart in Appendix C to that report that actually has counted these kinship out of care kids who came into the system. So we know that there is information out there about these kids. And that's because when a protection agency comes to your house and says it's court or you can sign this voluntary services agreement, for example, that would be an Ontario example, there is some documentation. Now, we recognize, and it's in the taxonomy report that's attached to the compensation framework, that there will be some challenges in identifying these children. There's no question about it. I don't want to simply say, oh, of course, they're all accounted for in this report. That's not what I'm trying to say. What I'm trying to say is that there is evidence. The researchers have identified these kids as a class of kids that they can actually count in some circumstances. And so what we did in the compensation framework was take a very child-centric approach. It's not the child's fault that they're not a number. I mean, that's ultimately what it comes down to. When you're in an ISC-funded placement, you have a number. But if you're not in the ISC system. And that's not the child's fault. So we appreciate it, and that's why you see in the compensation framework funding and support for the agencies to work with the parties to identify these kids. And it may be that we can't identify all of them. Sometimes the data certainly tells us in the taxonomy report, the agency is certainly going back, earlier in the 2000s, like the record keeping is problematic. We acknowledge that, it's in the taxonomy report, but there are creative ways to find these kids. And if we can't find them, that's one thing. But to just start from this premise that it's going to be too hard to find them because they don't have a number attached to them, let's just cut them out. To us, that's not in keeping with the order. And it's certainly not in keeping with the way child protection services are delivered across this country. So there are creative solutions to finding these children, and the researchers have started to collect that data. And we would say that, A, they were always included, and B, having trouble finding them is not a reason to cut them out.
So you think that the FSA is deficient? Your view is it's deficient currently in not providing any potential funding not just as per the knowledge that they have now about these people who weren't under their care, but there's no provision in the agreement for funding them if they're found to
That's
have
right.
existed.
That's absolutely right.
That's your view of the agreement.
I would say it's not even my view of the agreement. It's in black and white in the agreement. The definition of removed child under the final settlement agreement, which of course I now can't find, actually says, ISK funded children. It uses those terms. That's the first time that I had ever seen ISK funded kids in anything to do with this case in that way with respect to compensation for eligibility. It's not in your decision. It is not in 2019, it is not in 2021, and it is not in the compensation framework. So we knew there was always going to be a problem with data. I mean, to not belabor the point, but part of the reason that there's such a problem with data is because Canada was underfunding these agencies. They were funding maintenance at 100% of the cost, but they were underfunding the agencies in every other area, including IT and data collection. Which is why you see those line items in phase 2 of IFSD. They're critical to the ability to deliver child and family services in a good way. So, I'm not saying that therefore, this isn't going to be hard or easy, but it comes back to the rights of kids. The rights of children should not be determined based on whether or not the adults have enough paperwork. That's not what this case was ever about. It was always about making sure that victims who were discriminated by Canada were compensated. They had that infringement acknowledged by the 40,000. That's what the Act provides. So I have always understood on this point their argument to be they were never included. We disagree. And by the way, they say it's hard to find them. We disagree that we can't find them. It may be harder to find them than other children, but we can do that work. We can roll up our sleeves for these kids and find them. That would be our position on that.
Thank you.
Thank you. It's 11:15. Why don't we take 15 minutes break?
Sounds good. Thank you so much.
Okay, thank you.
Recording stopped.
it's fair to say that
Recording
we can
in
start
progress.
recording, and Ms. Clark, you can continue. Thank you.
Thank you so much. So first, a shout out to co-counsel David Taylor. It's very helpful on these files to have backup. And I wanted to come back to your question, Member Lustig, about this issue around non-ISK funded kids and when did this first come up. So I think it's a very important question. I would point you first to the certification order, and the site for this is 2021 FC 1225. And in the certification order, the definition of removed child does not include this limitation around ISK funded, non-ISK funded children. In the order, removed child class means all First Nations children who were under the applicable provincial territorial age of majority at any time during the class period and were taken into out-of-home care during the class period while they or at least one of their parents were ordinarily resident on reserve. So those kids were not specifically, if I can be fair to what my friends may say, they were not specifically mentioned in the certification order. Now, in the final settlement agreement itself, and that's on page 17, which we find at Exhibit F to the AFN affidavit, the definition, as I mentioned, actually specifically mentions these children, and it says removed child class or removed child class member means First Nations individuals who at any time during the period between 1991 and 2022, while under the age of majority, were removed from their home by child welfare authorities, were voluntarily placed into care, and whose placement was funded by Indigenous Services Canada. So that is where we see the introduction of this issue in the final settlement agreement. And to be fair to the record, you had asked me whether or not the Caring Society had raised this in the time before the final settlement agreement was signed, and we explained yes, that we raised this in an email in April of 2022, which is attached to Dr. Blackstock's answers. And in fairness, the Mooshum team did respond to that concern, and that's found at the chart that's attached to Ms. Walker's email of May 13th, 2022. So they did address our concern, and their response, which starts on page 4 of the chart that's attached to the email, sets out that it is their understanding that that your orders of CHRT 39 limited eligibility to children who were in ISK funded placements. And they go on to say, that in the underlying principle is not to leave children behind. We do not believe that the draft FSA excludes individuals eligible for compensation under the CHRT as the discriminatory nature of the federal funding and the primacy given the child removals were the heart of the tribunal findings. And then they go on to mention that there's a separate class action. So I just wanted to just sort of round out the record to make sure you had all the evidence. They did address it. And of course, as I hopefully made clear, we don't agree that these children were ever excluded from your orders. And certainly if they are, then there has to be a different way to address it because, and I would say we will have to come back on a very similar way that we did on the First Nations child issue. The orders are for children removed, not who paid for their placement. So I'm going to move from the ISK funded kids to some other critical areas where we say are the key departure, unless there are other lingering questions about these particular children.
Well, Ms. Clark, you may not be able to answer my question because I don't know if the conversations that led to the compensation framework are confidential, but if you can, and to be fair to your friends as well who will be able to reply, was this subject of removal and the children that were removed, the subject of discussion for the compensation framework?
So, I mean, that's a very good question.
This different view of interpretation, was it discussed at that time?
So that's certainly not in the record. All I can say about that, Member Malsh-Verdon, is that the language in the compensation framework is very specific, and in our view tracks the multiple options that are available to a protection agency when they become involved, right? So anything from kinship to what we deemed various custody arrangements, in our view, is indicative of the fact that it was not restricted to ISK-funded placements. ISK-funded placements are not what I would consider to fall under the umbrella of various custody arrangements. They are a foster placement or a group home placement paid by a service provider. So in answer to your question, to be honest, I can't recall specifically, but in my view, the language of the compensation framework was purposefully broad to catch kids who were removed, right? And as I tried to explain, removal means a lot of different things to a lot of different people, as does the term in care. When a worker, goes into a home pursuant to its mandated legislative requirements, it's not, the legislation does not, and we put some sections in the factum from various legislations. The social worker is not mandated to place a First Nations child in ISK-funded care. That's not what the legislation says. You have to keep children safe. And there are a lot of different ways to do that. And there are a lot of different places that kids can go when there are problems at home. And, in reflecting on your 2019 decision, I think we all asked that compensation, and I agree with what Mr. Wetke said yesterday. Absolutely, the AFN was asking for compensation to go directly to children. We don't disagree with that. That is absolutely fundamentally true. But the tribunal was clear that it in some ways viewed the worst case when kids were removed, not just from their homes, not just from their families, but actually also from their communities. And you'll recall that the request was actually for all children who were impacted by Canada's discrimination. And the tribunal felt that the compensation needed to go to those who were impacted by the worst case. And those parameters of home, family, and community did place some boundaries around who is in and who is out of those eligibility criteria. That's not ultimately what was asked for, but we didn't seek review of that decision. And the Caring Society now stands beside the tribunal on those boundaries around those worst case scenario children. Where we depart from our friends is this notion that you actually further restricted it to the type of placement. And in reviewing the record, there wasn't evidence led on compensation about the level of harm suffered on the type of placement. Arguably going to a secure treatment facility where, as a child, you have no rights versus, a foster home or a family friend. That's what the class action can compensate, these various different levels of harm. That's why we say we're not against the class action. We're not against the final settlement agreement. It's seeking to compensate a very different kind of harm. Here, what the tribunal did, in our view, was compensate for the infringement of dignity and the harm suffered between the discrimination itself and the rights that First Nations children are entitled to, right? That right to be adequately protected by the preventative services that all other children are entitled to, that's where the nexus is. And so even though the tribunal did, put those, I wouldn't call them boundaries, but, there are parameters around the eligibility for children, around home, family, and community, made sense based on the evidence. But there wasn't evidence about, the harm suffered by being in a kinship placement or being under a voluntary services agreement or going to a place of safety for the first 5 days while an investigation is taking place. That sort of nuance of harm was never what this case was about. It was about the removal. And that's why I tried to spend so much time on that particular issue.
Thank you.
So I'll move on to the other two areas of the departures, and I'll just start with the estates of deceased parents. In our view, this is crystal clear that you ordered compensation to be paid to the estates of deceased parents, and the final settlement agreement is not going to pay them. So I don't think, at least what I took from my friends yesterday, that there's a dispute about this being a very clear and unequivocal departure from the final settlement agreement. The question is, can you accept that? As I said at the outset, we say no, this is a right that has been entrenched. And then, of course, if you drive your bus past that question and into, we think we have jurisdiction, what can we do? We would say, in answer to your question, Member Lustig, this is another key area where you should not depart from the orders. And that's because, the estates of deceased parents and the compensation that will go to them is ultimately for the benefit of their children. And that's what the Caring Society has always been focused on in this case. There is a direct conflict between the final settlement agreement and the compensation orders on this point. And it's our view that the estates of all deceased victims should be compensated. So in deciding this issue in 2020, the tribunal was very clear about the foundation of its decision in awarding compensation to estates. And as we all know, this is found in 2020 CHRT 7, where the tribunal started its analysis really grounded in the objectives of the Canadian Human Rights Act and its remedial purpose. And at paragraph 105 of your decision, you talk about the specific facts and context of this case, and the Act's objective and purpose are the starting point in the panel's analysis. Quoting from the compensation decision, the proper legal analysis is fair, large, and liberal, and must advance the Act's objectives and account for the need to uphold the human rights it seeks to protect. One should not search for ways and means to minimize those rights and to enfeeble their proper impact. And in our respectful submission, this guidance that you provided applies very importantly to estates, but actually to all the rights of the victims in this case. The tribunal then goes on to quote from the decision of CN in Canada, which talks about how human rights legislation is intended to give rise, amongst other things, the rights to individuals, that the individual rights are of vital importance, rights capable of enforcement. And that's what we're talking about today. And going on to paragraph 126, the tribunal says, there is no explicit wording or language in the Canadian Human Rights Act barring payment of compensation to the estates of deceased members for pain and suffering or willful and reckless discrimination. In fact, the panel finds it would be unfair to the victims who have died to deny them and their estates the compensation that they are entitled to. The panel finds that the fact that some victims have suffered and died prior to and during these proceedings should not preclude them from receiving some form of vindication in having their suffering recognized and their estates compensated. This reasoning becomes even more important if victims have died as a result of the discriminatory practices. A technical argument distinguishing living victims and deceased victims in this case does not advance the remedial purpose of the Canadian Human Rights Act. So the Caring Society is of the view that it would be unjust to walk away from these victims now. In our view, there is no principled basis put forward so far as to why we would leave these estates out. Another important consideration I just wanted to raise is this issue between adoptive parents and biological parents. Ultimately, we do disagree with the AFN's interpretation in its reply submissions. When this issue of biological parent was raised in 2020 CHRT 15, the issue was not adoptive parent versus biological parent. The AFN was actually responding to the Chiefs of Ontario and Anishinaabe Nations requested for an expanded category of caregivers. And now I'm referencing paragraph 28 and 29 of your 2020 CHRT decision. In sum, the Chiefs of Ontario believe that the reality of families in First Nations communities means that aunts, uncles, and other family members may well have been caring for children at the time of removal and submits that such people should not be precluded from entitlement to compensation. In sum, the Anishinaabe Nation submits that it is not unusual in Nan First Nations for individuals other than parents or grandparents to act in a primary caregiving capacity. This reality is not reflected in the compensation decision order. The Anishinaabe Nation requests the category of eligible caregivers to be expanded from parents or grandparents to include aunts, uncles, cousins, older siblings, or other family members and kin who were acting in a primary role. The tribunal then goes on to talk about what AFN's position was. At paragraph 45, the AFN submits the compensation scheme is meant to be objective, not subjective, to investigate the relationship between an adult and child, removes the objective element and places it in an interrogatory process, which goes against the AFN's strong position that children in care not be subjected to the same traumatic process as residential school survivors in the independent assessment process. The panel finds this to be the correct interpretation of the approach taken by the panel in the compensation decision. Now, importantly, section 12.2 of the compensation framework actually acknowledged that further work would have to be done on this issue. This section states in part, parties will continue to work collaboratively to develop criteria to identify and expedite the processing of potentially complex claims. For example, a child removed multiple times, when removals involving different parents or different grandparents. The parties have agreed to develop further guidance on this issue, which would weigh factors such as who is the biological parents, who would be the legal guardian, and other relevant matters. So in our view, this question of whether adoptive parents were in or out was actually never answered by the tribunal or the compensation process framework. We frankly just never got that far. Now, with respect to Jordan's principle, there are questions. And it is our view that at this moment, we cannot actually tell whether or not your orders and the children that you identified are in. And this brings me to my submission on prematurity. So this is a huge problem. And we acknowledge that it's possible that the approach that is going to be set out by the class action could be, in some respects, in harmony with what you have ordered. But we don't know that right now. That is the problem. And when I say that, I'm not saying that in a disrespectful way to how class actions may roll out in the federal court context. Certainly, class action final settlement agreements leave some questions unanswered. And we know that, and there are lots of good examples of that. But this is unlike anything else that we have done in this context. We have orders that define certain terms, and then we have a class action that defines some of those terms and is leaving others open for later. That is the difficulty with this case. It is this uniqueness. So my comments are not to be critical to the class action process. My comments are simply a reflection of the fact that we are in an exceptionally unique circumstance where you have made very clear orders about the definitions of certain things, and the class action, because it simply operates as a different animal, it takes approaches to these questions in a different way. It's not applying a human rights framework to compensating these children and their families, which it shouldn't do because it's in the class action context, but now leaves those of us over here on the human rights side and the victims who have seen their rights affirmed with very, very big questions. So in our view, particularly on Jordan's principle, there are too many unanswered questions that would actually allow you to even amend your Jordan's principle orders in keeping with what we see reflected in the final settlement agreement. And let me take you through this issue, and then I hope we will break for lunch as requested. So in our view, even if you find, and I'm going to keep coming back to this, not in a way to hammer the point, but just to be very clear. So, particularly based on our discussion, Member Lustig, even if you do find you have the jurisdiction to amend some of your orders to keep them in line with the final settlement agreement, it's our respectful submission that you actually can't do that with respect to Jordan's principle. The definitions in the final settlement agreement are contingent on two main things that we don't know. One is the assessment tool that has been developed for Jordan's principle under the settlement framework, and two, the definition of delay. Now, there's two fundamental problems, I would say, with the framework for essential services. And that is, first, that it is unclear how the framework of essential services will actually establish a method to assess two categories of essential services under the final settlement agreement. And those are under Article 6.06 sub 3. So what we have now is an essential services framework that provides very little guidance on how these children's, essential services, unnecessary delay and denial, service gap, et cetera, how they're actually going to be weighed. It leaves open the question, how is a confirmed need going to be assessed? And what the agreement says is that the impact is going to be measured based on objective factors assessed through a culturally sensitive claims form and a questionnaire designed by experts. Again, there may be nothing wrong with this approach, but the problem is twofold. One, the expert report itself is not before you. And as you were clear, the evidence on this motion is closed. It was not provided to us in advance. The experts have not been made available for cross-examination, and the report itself is nowhere in the record, except in a footnote in reply submissions received on Wednesday afternoon. So in our view, it's almost impossible for us on this motion to speak to that assessment tool with any level of knowledge. That is a concern. And so we would really urge you, although it may be a very good assessment tool, you just can't know now based on council submissions about what it says and what it doesn't say. The second, I think you're on mute, Member Lustig.
Yeah. So you were talking before you made the point about prematurity, or before you talked again about the point about prematurity. You were on your sort of list of things that were different, shall we say, and different to the negative in your view. And you had talked about the difference of opinion with respect to whether it didn't matter who paid, and the funding at Government of Canada placements. And then you talked about estates, and you felt that those should be maintained, that the states should be paid. And then you sort of moved over to a different kind of, I didn't know if it was an area where you say that the FSA is deficient because it lowers the $40,000 or what. And then you moved over to prematurity. So just to take me back to I don't know if it was 3 or 4. Could you just summarize? I don't want you to repeat anything you've said, but if you could just sort of summarize each one of those so that we get that kind of closed.
Yes, absolutely. Absolutely. So the key departures, in our view, are really set out in the chart that we've attached to our factum. And from a principled perspective, yes, there are 4 issues: the non-ISK funded children, the estates of deceased parents. Then there are questions about parents that we've set out in our factum. And then Jordan's principle is our final, what we would say, key departure. And what I was trying to do, but obviously not clear enough, was actually demonstrate how Jordan's principle actually bridges both sides. So on ISK funded kids, the class action is clear. They're out. On Jordan's principle, the question is, they could be a key departure. They could not be a key departure. We don't know yet. I mean, one way to look at it and I was trying to bring peace and be positive. I mean, one way to look at it is a key departure because it doesn't simply mirror what you have already ordered. Another way to think about it is the final settlement agreement leaves questions unanswered. And they've asked the questions and they've said it directly in the final settlement agreement that there is other work that they have to do. So you could view that as a departure, which we would say at first instance it is, but it is also a question of prematurity. So in our view, how can you even do what you're being asked to do if you don't know the answer to these questions? That's really the Jordan's principle issue. It certainly does depart because it doesn't just take your definitions and put it in the final settlement agreement. But another way to think about it is they may ultimately arrive at the definitions that you gave, or at least the implementation will have the same effect. We don't know. That's really the problem. We don't know that would happen.
But the problem or the issue regarding both the estates and the children who were removed not to ISC facilities, that's a sort of a purely monetary kind of result, that there's a lowering or there's an exclusion of the compensation. And I'm returning to your use of the words $40,000 just for simplicity. Mm-hmm. This is something different than that. It's not as clear as that in terms of the monetary. And tell me if you think I'm wrong here. Hasn't Canada and the AFN provided for sums of money that are based upon their best guess of what the numbers might be and what the resolution of these unanswered issues with respect to interpretation or definition? Haven't they said that? Isn't that in their position?
Yes. So what they say about the numbers is that while they can't guarantee the 40 for everybody who may be eligible, that's their goal. So they have said that, and that's very clear in the answers to cross-examination from AFN's affiant. And I don't, and certainly Mr. Cowper said that yesterday as well. The goal is to compensate these children as much as they can. I think our concern is people who experience discrimination under Jordan's principle, as you've set out in your orders, are entitled to $40,000. So, that is a fundamental problem with the approach. And, there's nothing that we can do about that at this stage. They don't know how many claimants they have. Of course, our primary position would be, and you can see this in Dr. Blackstock's letter from January of 2022, is that we want the orders to be respected. We want the children in particular to have guaranteed that they will get the $40,000 as ordered by the tribunal. The problem with Jordan's principle, we would say, is while we appreciate the commentary from our friends that that's the goal, they don't really know how many Jordan's principle claimants there are, because it's not tracked. I mean, this is a very different issue, right? Social service access and child welfare involvement is different. We appreciate that. We understand that. We have concerns with how they ultimately are going to assess these claims. And it's hard to even assess at this point, we would say, whether or not we can even say that they are in harmony. I think that's the concern, is that, it's very, very hard to know whether or not the Jordan's principle kids are going to be in or not. We don't know whether or not this basket of children will actually meet the parameters of your order without knowing more. And it may be that the assessment tool, because it's being piloted, is what we understand from Mr. Cowper yesterday, leaves more unanswered questions. I think the issue is the delineation between the two groups is the problem. We don't know exactly how this is ultimately going to be, how it's going to roll out. And that's why I say this is a bridge question between a departure and actually is it not really premature at this stage to ask you to affirm the process when you don't know what the process, A, what the process is, and B, you don't know what the outcome to that process will be?
So on this particular item, what would your suggestion be? I mean, what do you think? That we would sort of allow payments of other things to take place that are not contentious and wait until whatever the numbers are to fulfill whatever it is that is needed in your view to make those determinations? Is that what your thinking is?
So I think, again, not to be annoying about it, assuming you say you have jurisdiction, you know, that's an exceptionally important question. And I think that's why our alternative suggestion to the panel is for you to provide us some guidance and for us to go back and work on these questions together in the dialogic approach within the confines of this proceeding. I mean, it's having access to the tribunal to assist resolve questions that we cannot arrive at a consensus is critical. And we haven't had that opportunity within this process, notwithstanding what my friends would say about the Caring Society's involvement. We couldn't take questions of disagreement to anyone, anywhere, to resolve on a final basis in the way that we have built this, I think, incredibly important dialogic approach in this proceeding. That's why our alternative relief, first of all, that's why we provided alternative relief. Let me just start by saying that. We are not saying to the tribunal, yes or no. We are saying, we think you're going to have to say no for all the reasons I've already said. But if you think you can, there is a way forward to simultaneously protect the rights of the victims within a human rights framework and ultimately arrive at a place that sees compensation paid as quickly as possible to the victims. And, you know, we see the way forward as using that dialogic approach. It may be by the time we sit down and we have the answers to some of these questions, there will be a lot less things on the list that are contentious. It's possible. And we should give these kids that opportunity, in my view. We should really give the victims that you've identified the opportunity to see this resolved on consent in a consensual way. And use you as the expert. I mean, let's be clear about what Justice Fable said about this tribunal's level of expertise. You have been on this case since 2012. You understand the record. You understand the evidence. You understand the parties. You understand the positions. There can be no more efficient way, in our view, to ultimately address the places of departure and where we have disagreement. I think that, in our view, would be the way to address this problem. And I think you could order timelines and you could order reporting. We could come back to you in a different way. Now, that assumes that, you know, we could get commitment from the government to engage in that process. Because, as I said at the outset, it is, in our view, inherently unfair that the tribunal has been placed in this position to say yes or no, or by the way, it's a term of the settlement agreement. If you don't approve it, there is no settlement. But, you know, I was heartened by some of Mr. Vickery's comments yesterday about what is trying to be achieved here. And I think that using that dialogic process to resolve these issues would be certainly in keeping with the trajectory of this case.
That would delay the payments to a lot of people, I would think, as compared to us endorsing. That would create delay. But leaving that aside for just a moment, on the areas that you disagree, would it be your view of this approach using the tribunal, which I'm not supporting or
I hear you on
want to
that.
understand what you're saying, that the decisions that were made by us would be binding on the parties, that would be the effect, that we would take an issue up and say, you know, yay or nay to those issues. Is that kind of your approach?
that could be one way to address it. And I would say on the delay issue, because I appreciate that it's a very important issue. There's nothing stopping Canada from paying on the places where there is agreement, right? There is nothing stopping Canada from paying $40,000 to those, for example, in ISK funded placements. So we agree those kids are entitled. So that money can go out the door now. We agree that the estates of deceased children should receive funding. That money can go out the door now. We don't have to delay the whole process in order to fund to get compensation into the hands of those children. Now, there may be some mechanical issues that smart lawyers, all the smart lawyers in this virtual courtroom could work out. But in my view, there's actually no legal impediment other than Canada's concerns about protecting its own liability, that we couldn't actually have the funds paid out now. We could do that. That could be done. And then, as you suggest, or you weren't suggesting, I'm suggesting, you're asking, address the other issues where we have disagreement, work together on those, and then come back to you for guidance.
Except that what we heard from Canada and AFN was that, or is that, this agreement is built up in a way that one piece is dependent on another. And so if they're in a position where they're paying out in areas where there's no contention, and then they find out we rule that, you know, they should pay in some other areas, that has the potential of throwing out the, you know, the calculus of the $20 billion and how it was arrived at. And so that's a real practical problem.
I do agree that that is a practical class action problem. I absolutely acknowledge that. And I think that my concern with the alternative is, and so what, because they built that agreement in that way, we're just going to say too bad for the other victims? I mean, that's the consequence. In our view, there has to be another way. We can't have come this far and recognize the rights of so many only to have an outside proceeding dictate how this is all going to end. That can't be how this works. That can't be the end of the story for these kids and their families. There has to be a third way. And I think what I would suggest is, you know, I'm certainly going to think about this question, Member Lustig, over the lunch hour. I think it's a really important question, but I can certainly say with conviction that it can't be a zero-sum game here. We can't leave these kids and their families behind just because the class action side of this file structured their agreement in a way that works for the adults. That can't be how it goes.
Okay, thank you.
I'm mindful of Member Marshall-Dunn's 30-minute or 45-minute time limit. We've been going for 40 minutes, so I would be happy to take a break if that's in agreement and try to address Member Lustig's question over the lunch hour, and also maybe tighten up my submissions a little bit.
Do you know how long you would, and I realize that we jumped in, but it was important that we did. So do you know how long you will have after lunch?
Depends on how many questions I get. No, just kidding. I would say, you know,
It's
maybe
fair.
maybe an hour to an hour and 20. I'm going to try to bring it all together because the questions actually have been really helpful to understanding, you know, just how complicated this whole thing is.
Okay, so let's break for an hour and we'll continue after that. Thank you. Have a good lunch.
Recording stopped.
Without them, and they asked AFN to text them if there was something that you needed their attention on.
Oh, perfect. Thank you. Good afternoon. I hope that everybody's lunch was
Recording
nice.
in progress.
And we'll continue with Ms. Clark from the Caring Society, if you're ready.
I am ready. Thank you. So before the break, we were talking about the issues of prematurity. And Member Lustig, you asked a really important question that I am almost certainly going to, not almost certainly, I will answer. But before I do that, I just want to finish on the delay, not on the delay issue, on the prematurity issue, because it loops into what options are on the table about what we do about all this. So just very quickly, in addition to what we don't yet know or understand about the Jordan's Principle assessment tool, we also don't know what the definition of delay itself is. In your orders, as you know, you've made it very clear that in the compensation framework and in your decision that the definition of delay is where a request was not determined within 12 hours of an urgent case or 48 hours with respect to other cases. And the compensation framework goes on, as we know, to say that there's a rebuttable presumption that Canada can push back on if there is a case with reference to a list of contextual factors. So that's in the compensation framework, and it provides guidance as to how delay is going to be dealt with. Conversely, in the final settlement agreement, delay in the definition section is defined to mean where a member of the Jordan's Principle class or trout child class requested an essential service from Canada and they received a determination on their request beyond a timeline to be agreed to by the parties and specified in the claims process. So this is, in our view, a very important question because the rights of children to have ready access to the support services and products that they need was actually part of the discrimination that you found. Sort of being able to push back, the availability of support services and products was in and of itself a problem, which you identified. And so this is another area we would say needs clarification. You can't actually amend your order to provide a definition for delay if you don't know what the definition is that they are requesting. Perhaps the definition they're requesting is 48 hours for urgent cases and 72 hours for non-urgent cases. But maybe it's not. Maybe it's a month for urgent cases and 6 months for non-urgent cases. We just don't know right now. And so we would say in our submission, it's premature for you to be able to actually amend your order in line with this particular issue. And so this brings me to your question, Member Lustig, about what do you do about all this? And, I really would pause to say, this is a problem that there is this term in the final settlement agreement, this poison pill, if you will, where if you don't approve the final settlement agreement, it's at least suggested right now on its face that it all falls apart. And that is a huge problem. So we've suggested that you dismiss the motion. We've also suggested right before the lunch break, as I took you through this idea of asking the parties to go away and consult and come back to you with amendments or suggestions, further in line with the dialogic approach. So, and you raised the issue of delay. And so we worked on the lunch hour on a third option. And again, I preface my comments by saying around the jurisdiction piece, we don't think you can efface those rights that have been ordered. But what are you going to do if you think there is something you can do? And in our view, we're going to take a red light, yellow light, green light approach. There are things in the settlement agreement that maybe you're going to green light. There are things in the settlement agreement that you might put a red light on. Non-ISC funded children, estates, things like this. And then maybe there are things that have a yellow light. And I do note, and the reason I bring this yellow light issue up is around your concern around delay. So we know, as Mr. Cowper mentioned yesterday, that there is another step in the process. They have to go back to the federal court. At least right now, it's scheduled for December. So there is a world where you could green light certain things in your decision, red light others, and then give a yellow light on things like Jordan's principle, the definition of delay, and ask the parties to return before December, before the claims process material would go to the federal court, and have it addressed in that way. And I'm sorry, you're on mute.
Thank you. Yesterday I was not on mute and I made a couple of comments about my wife's apple pie. I think I've been a little bit leery about that button, but anyways. So now you're talking sort of an attempt to perhaps negotiate a little bit. And while we're here in a hearing, we also said to you that this was supposed to be a practical hearing where we have some discussion. And so as long as the other parties don't disagree, I think it's a good thing to, have the dialogue. Maybe it won't go anywhere, but have the dialogue. So it would be helpful. You've spent some time thinking about this, and you got to the red light, green light, and the yellow light or orange. I don't know which one it is, but
I think it's actually called amber, but I just go with yellow.
Okay, so that's very simplistic because, and it's good because I'm a very simplistic person. And but it would be nice to have the caring societies a little bit more specifics with respect to what is green, what is red, and what is amber from your perspective. It would certainly clarify things for everybody because quite honestly, and this wasn't part of your presentation. I don't know if you're going to speak to this, but one of the things that troubles me, and I'm speaking for myself here, is that the other side, in particular, the AFN, with whom you were connected during this whole process, and the last thing I ever wanted was to be, determining a dispute between you and them. But they have made the point that they're the representative group, as well as the chiefs are a representative group, and NAN is a representative group, and you fulfill a wonderful and important task, but it isn't really as a representative group, except for the society members that you have. And so what they've essentially said to us is, we went out, we're the ones who represent these people. We went out with this thing. We engaged our constituents and we had to make compromises. It's not perfect, but here's what it is. And so then you go back to the poison pill that you just mentioned. And if it happens to come to be, the concern that you've expressed, that I have too, and I'm sure that Chair Marshall Dolan agrees with this. We have real concerns about, on a personal level, disentitling people that we did entitle in our opinion. But on the other hand, if we lose this, we're going to not only be disentitling them, we're going to be disentitling a whole bunch of new people that we would have been happy to entitle going all the way back to 21. So the disappointment factor is huge, huge. And and I have to be honest, it outweighs, but just because of the numbers, the obvious numbers, it outweighs the sort of disappointments in individuals that you're concerned about. You're concerned about. We're concerned about too. But that's a large number on the other side. And so we're in a really tough spot here. And any help that we can get to resolve this would be great, because I think I'm speaking for everybody here. This is a dilemma. Nobody, I'm sure that the AFN, if they had $22 billion to work with, I'm guessing could have probably moved in, and I'm just using a number here, could have moved in the other people, but there was a number, and there is a number, and that's been accepted. And that's a fundamental, I think that's the first thing that almost came out of the mouth of one of the presenters. So I take that, but we need a path. We need to help you with the path, to help us, but more importantly, to help a lot of people that you don't represent. And so we would appreciate, your best efforts to come up with some solutions. They may not be acceptable at all to the other side, but some solutions that would help.
Yeah, and I really appreciate those comments, Member Lustig. I think first of all, I would say absolutely that the Caring Society has a very different role than the AFN or the Chiefs of Ontario or Anishinaabe Nation. But I think where we're at in the process is not from the beginning. We don't stand here today to allege that we represent any particular group of children or any particular group of parents. What we see our role is actually defending the rights that have already been won. And so I certainly appreciate the work that has been done. And when I say me, I mean the Caring Society. Of course, in what you're talking, expanding, the range of people who will be hopefully compensated as a result of the discrimination. And the compromises that were made within the parameters of the final settlement agreement. I mean, certainly when you look at the initial statement of claim that was brought forward in these proceedings, there have been compromises, not only that touch on rights that have been won in this proceeding, but even just within the confines of the class action itself. And so, of course, we respect the right as the Assembly of First Nations and the representative plaintiffs to compromise from where they began from. The dilemma we have here is that the victims in this case, the individual rights that have been awarded under the Canadian Human Rights Act have already been won. And in our view, whether or not it's the Assembly of First Nations, whether or not it's the BC Federation, whether or not it's FSIN, it doesn't matter whether or not, in our view, a government, a First Nations government, a municipal government, a federal government, any level of government that we respect to, take direction from their membership, any organized and any government, any level of government, in our view, cannot negotiate away the rights that have been won. That is a fundamental principle we would say is critical to the analysis that is here before you. Yes, we acknowledge there is a difference between the Caring Society and the Assembly of First Nations, and how we got here is critical. And I think we would echo your concerns about what you're seeing as a fracture of disagreement on this issue between the AFN and the Caring Society. It does not serve the victims of this case in a good way that's happened, but it has. And reconciliation, in our view, includes telling your friends when you think they might be wrong. Okay, so in terms of the process, I think absolutely you can green light anything that does not bump into a derogation of rights that you have already made. So in your earlier question, can you expand the removed child class from home, family, and community to home and family? Yes, because that doesn't derogate from the right, it expands the right. Can you order compensation to the deceased estates of deceased children in the way that it's framed? I think you can. Is an implementation issue? I think you can. The things that we would say are red light issues are the non-ISK-funded children, the estates of deceased parents, certain parents and caregivers, as we've set out in our factum, and then we would say that's the Jordan's Principle assessment category that is in the yellow light area.
That's in the yellow light.
That's in the yellow light.
Okay.
And that's why I want to be really clear. And again, it's not a criticism of the class actions approach. It actually might be fine. It might be fine. There actually may be harmony between your definitions and how it's going to roll out in the class action. But I think it was so hard fought to have those victims recognized by the tribunal. I mean, the arguments that were made by the government against Jordan's Principle compensation, both before you and at the federal government, were significant. So we're very wary now, given what's happened and the road that has been made for these children, these child victims and their families, to just quickly flip the switch when we actually don't know. So that's why I put that in the yellow light. I know we're all very busy, but I know from our perspective, the Caring Society is prepared to roll up its sleeves and work with the class action folks to actually look at the assessment tool, talk to the experts, and come back to you before the claims process hearing in December, if that's when it ends up going, and seeing whether or not there is a harmony there. And if there is, there is. And that would be amazing. And if there isn't, then we're going to need further direction from you about how to deal with that problem. But to us, that the uncertainty on such a big class of kids is very problematic. And to just cross our fingers and hope that the way that they are approaching assessment lines up with the way you have ordered these children to be assessed is problematic.
Had our compensation decision stood as it has to this moment, anyways, if there was no FSA, what would your position have been as far as rolling out the Jordan's principle part? You wouldn't have had those answers yet, right? Because you would have needed to go through the process as well, no?
Yes. So in the compensation framework, what we envisioned the plan to be was, once we knew that Canada was going to stop fighting us and the AFN on just the entitlement of compensation, then within 15, we tried to get it business, it was what, 15 business days, we would then work towards an implementation date. And from that implementation date, a series of steps would have had to have taken place. Now, that could have started when the compensation framework order came out in early 2021, but now we are in late 2022. So you're absolutely right, that work has not been done, but we are ready. And I would say now that there are things that we can do if the appeal was released and if the FSA hadn't happened, that we would have been working very diligently to get the compensation to victims as quickly as possible. It was a principle within the compensation framework that we would work as quickly as possible to have those funds distributed. And quite frankly, the class action folks have also done it relatively quickly. So we know it's possible to do. We can do it. And this really maybe is an opportunity for these two proceedings to come together to cross-pollinate on things like implementation of Jordan's principle. Why can't we do that? To me, if ultimately you decide you do have jurisdiction, then in our view, that actually means that your creativity, your flexibility, your innovation, in some respects, is boundless to the victims that you've already identified. You can craft something unique here. And I do hope, if we get there, that it would be signed off by all parties, because obviously that makes it a little easier. You'll recall when we were first ordered to consult with Canada in 2019, they brought judicial review. It wasn't until after the stay was not granted that we started to get to work. So hopefully that would happen. And it is possible. It is possible. There is time, I guess, is my point on this issue. There is a way to not delay the rollout of the compensation by doing some of that work between now and the claims process hearing.
Okay, thank you very much.
Thank you. Okay, I'm going to provide my final submission, and then if it's okay with the panel, I would like to take a very quick break to just make sure that I've covered everything. So I probably be maybe subject to questions 20 minutes, and then I would just ask for a short break. So, it is our view, and I really do appreciate, Member Lessig, your questions about the dilemma that the panel is in. I mean, what an extraordinary moment to be in when you have to consider what's at stake and how you're going to make this decision. And so in our view, if you decide that you have the jurisdiction to consider the relief, then you will have to take, we would say, a principled approach grounded within the human rights context to make the decision on how you are going to support and protect the victims that you've already identified. We do think that you should not make this decision based on what I will call outside forces. The magnitude of the number and the parties that are involved. At the end of the day, in our view, your responsibility is to the individual victims that you have supported throughout this process. And the political ramifications of the choices and the class action approach is ultimately irrelevant. And I think that that's important. It's also irrelevant about who ultimately requested the relief and why did it matter. You have affirmed the rights of individual victims in this case. And, you know, the forecasting that has taken place in these submissions, both written and in oral, don't really line up with the legal requirements that the tribunal should take under consideration. Instead, it's our view that the motion should be considered on the current record and pursuant to the relief sought, should adopt a human rights approach consistent with the guidance from the Truth and Reconciliation Commission and the rights protected under the United Nations Convention on the Rights of the Child. So in our view, there should be three guiding principles to the work that you're being asked to do here. First, that you place the children at the center and use a best interest of the child approach to consider the outcome. Second, that your decision should be grounded not only in the evidence on this motion, but also in the evidence that has come before it. And finally, we would urge you to adopt a human rights framework analysis to how these decisions are being made. So with respect to the best interest of the child, it's our submission that your primary focus, as it has always been, is the child. So when you're deciding whether or not the final settlement agreement is in the best interest of the child victims in this case, we think that you need to put those kids at the center. Each individual child. How will each individual child victim that you have already identified experience the result of this motion? In our view, your duty is to those children, and not just because I'm saying it, but because the Canadian Human Rights Act requires it. The tribunal has always placed children at the forefront. You have told us, and we agree, that children's rights are human rights, and we think that approach needs to be employed. Should not consider the relief sought through the eyes of the adults in this room, who have many interests at stake on this motion. Instead, look to the children. And while it is tempting to celebrate that some children will get more than $40,000, it's not a principle to be applied in this context. That is a principle from the world of the class actions, where there is no cap on financial compensation. That is not a bad thing, but it is not applicable here. And perhaps that's why it should be, because compensation in a class action is not about the infringement of dignity or human rights. Compensation here, however, is to affirm this fundamental principle as Canadians. The second area we would ask you to consider is the evidence. Using the evidence to guide your decision is critical. And the federal court spent a lot of time acknowledging the fact that your decision on compensation was rooted in a clear and unequivocal evidence of harm. We would say again that you should come back to this evidentiary basis to wrap your arms around what you have heard both in the record and what came before it. Now you are being asked to make different orders about the level of harm experienced by some victims who will receive nothing or less than what you have already ordered. In our view, if you are to make a decision, it must be grounded in the evidence. And although we heard yesterday from both Mr. Cowper and Ms. Corbier about some consultations, about what plaintiffs are saying, about what others are saying, that is actually not in the evidence. And I would just caution that this panel has been clear that it's only going to make orders based on the evidence. Finally, the evidence about the pilot assessment for Jordan's principle is also not in evidence. And so we say that that should be disregarded. We know it's out there, but what it says and how it's going to work, we know nothing about. In our view, until you actually have that evidence, you won't be able to make a principled decision about whether or not you can or cannot green light this final settlement agreement or even amend your orders to keep in line with it. Now, in answer to one of your questions yesterday, Member Lustig, I wanted to talk about very briefly about who has and who has not objected to the final settlement agreement. And I think we would just point to two important considerations. First, those who are being cut out of the final settlement agreement are dead. The estates of deceased parents, those people cannot come forward. Children who are in non-ISK funded placements may actually not even know to come forward because they may not have known themselves who paid for their placement when they were removed. And finally, under Jordan's principle, how can anyone actually assess whether or not they are in or out, whether or not to object or not object? The criteria is so unknowable at this point. I would also note that the essential framework was only made available in mid-August, and that the motion material in relation to the final settlement agreement was only filed on September the 6th. So yes, we certainly appreciate that there have been no objections registered yet, but it's important that we keep the context of what that means in our minds. Second, we do know that there are some concerns out there. As evidenced in Dr. Blackstock's affidavit, there are some aspects of the final settlement agreement that have raised concerns from leadership and those across the class actions community. As we know, the Federation of Sovereign Indigenous Nations passed a resolution in relation to the compensation award, which is appended as Exhibit C to Dr. Blackstock's affidavit. That resolution reads in part, that the AFN negotiators and lawyers working on AFN's behalf are not authorized to reduce the CHRT compensation amounts for eligible victims or limit the scope of eligible victims, and must respect the compensation framework agreement and compensation entitlement order as a minimum standard. As far as we know, that resolution remains on the books. There is also a resolution from the First Nations Summit comprising approximately 150 of the First Nations of British Columbia. At Exhibit D to the resolution, it reads in part, the First Nations Summit Chiefs and Assembly affirm that the Assembly of First Nations in Canada are not authorized to seek a reduction in the compensation amounts for eligible victims who are members of First Nations in British Columbia, or to modify the compensation framework agreement and compensation entitlement orders CHRT 39 and CHRT 7 without the free, prior, and informed consent of the First Nations of British Columbia. That's not to say that the Caring Society expects perfection or 100% a consensus across the board. That's not why I raise this. I simply am pointing out that there are voices out there that do not agree. That doesn't mean that the final settlement agreement shouldn't ultimately be approved, but it's important context and evidence that you have before you. There have also been concerns raised by the Class Action Clinic at the University of Windsor. We know that in July of this year, the Class Actions Clinic wrote to Counsel for the Class Action to set out some of its concerns regarding the timing and the notice of the settlement agreement. The Class Action Clinic recommended that the approval hearing be rescheduled to allow potential claimants to actually have enough time to consider what is being asked of the court. Again, I'm raising this evidence to simply say that there are concerns out there and that those are in the evidence. It's important that we understand the context of what's being asked. And in our view, the resolutions from the First Nations Summit and FSIN reflect this idea that there are already rights that have been won. That we cannot compromise the rights that are in the hands of the children and those who are entitled. And finally, we urge this tribunal to take a human rights approach to examining the final settlement agreement. This role is not analogous to that of a court faced with a motion for settlement approval in a class action. The Canadian Human Rights Act does not grant the tribunal the power to approve class actions as either fair or reasonable. Instead, the question for you is, are the human rights of the victims in this case advanced by what you are being asked to do? Are you meeting the objectives of the Act to give these children the lives that they so rightly deserve? That's the approach. The Commission, the Caring Society, and the AFN defended the tribunal's use of the dialogic approach in their responses to Canada's application for judicial review. And the court agreed, finding that this approach reflects the flexibility that is required of the tribunal to fulfill its challenging statutory mandate, and that it reflects the Canadian Human Rights Act encouragement of flexibility and innovation. The federal court was clear that human rights compensation is not equivalent to damages in tort. It wrote at paragraph 138 The Canadian Human Rights Act is not designed to address different levels of damages or engage in processes to assess fault-based personal harm. The tribunal made human rights awards for pain and suffering because of the victim's loss of freedom from discrimination, experience of victimization, and harm to dignity. Importantly, the federal court distinguished between remedies provided under the Canadian Human Rights Act and those pursuant to a class action, making it clear that both can actually be pursued at the same time. In our view, it would be inappropriate for this tribunal to assess this motion using standards set in the class action context. Finally, the Caring Society submits that excluding certain victims whom the tribunal has already found to be entitled to compensation, who have experienced the worst case violations, would be contrary to the objective of recognizing the infringement of dignity and harm caused by the discrimination. Protecting the integrity of human rights, of the human rights regime, must guide the determination of this motion. To that end, the Caring Society really urges this panel to consider the broader implications, not just on this motion, but on the integrity of the entire human rights regime, including those involving other First Nations cases. In our view, allowing this motion as it stands would send conflicting messages about the nature and obligations under the Canadian Human Rights Act. The Caring Society again urges the tribunal to reinsert the important principle that human rights are binding. Canada should not be allowed to contract out of its obligations under the Canadian Human Rights Act to trade off reliability and protections under a private agreement. You have a critical opportunity, in our view, to stake the territory for the proper forum for discrimination claims. Human rights regimes were designed to have exclusive jurisdiction over discrimination. That is made very clear by Justice Abella and Honda and Keys. We are here to provide and offer comprehensive protection for discrimination complainants, allowing an outside settlement agreement reached in the context of a civil class action, no matter how good it is. When it invalidates rules and rulings already made, it has the potential to erode our entire system. Parliament's intention when it adopted the Act was to create a system tailored for these victims and the very unique and specific social wrongs of discrimination. That is what is at the heart of how you are going to do your analysis. You have taken great care thus far to hold Canada accountable for its discrimination and work to safeguard the substantive equality rights of the victims in this case. We have not heard any discussion from the class action side about the substantive equality rights of the victims in this case, or how those rights will be advanced in the payout of this settlement. I would just say finally on this point that you're being asked to consider a negotiating down. You're not being asked to elevate. And that is the issue. The circumstances of this motion are what causes concern. You're being asked to trade the rights of some victims for others. That is inappropriate and not in keeping with the Canadian Human Rights Act. You have an opportunity to stake the human rights regime as the final refuge for the disenfranchised and the disadvantaged. And if you are going to entertain this motion, it's our submission that you use those tools within the Canadian Human Rights Act, within the human rights regime, to protect the rights of victims. Ultimately, you have to give serious consideration to the exercise of your jurisdiction to ensure that the rights of those already entrenched are safeguarded. There are ways to flexibly implement your orders going forward, to see places where there can be consensus and synergy and working together. We agree with the powerful statements of Justice Favell that my friend Mr. Wutke took us to yesterday about reconciliation, but that's not what is happening here. Negotiation and reconciliation are critical to the path forward, but effacing rights that have already been won would be a retraction of that principle. So I've come to the end of my formal submissions. Subject to your questions, I would like to take a very short break and then just wrap up.
Yes, thank you. How long do you need?
I would say 10 minutes, and then I'll probably only be 10 minutes in wrap up.
Okay, so we'll break for 10 minutes.
Thank you so much.
Recording stopped.
we should be ready.
Thank you so much.
Is Mr. Smith there? Hello? Okay.
My apologies, Member Marshall. I didn't realize my video was still off, but I'm here and ready to go.
It's okay. It's okay.
Recording in progress.
All right, we have everyone. Ms. Clark?
Yes, thank you. Thank you for that that short break. I actually will be briefer than anticipated. Of course, subject to Mr. Lustig's questions, which I'm happy to take anytime. So we really just want to end today. Well, first of all, we want to thank the panel for holding this hearing, because it's actually resulted in some very important dialogue, we think, about the issues and the complexity of what's being asked of you today. And so we really we do appreciate the time that you've taken to engage with the material and to talk to us about the Caring Society's concerns. And so we just want to end with really some reflections about what's being asked of you and where do we go from here. It is important to note that over half of the victims of Canada's discrimination in this case are still children, and that they have not consented to anyone or any party, including Canada or the AFN, of having their compensation reduced or eliminated. This is particularly so with children who are in non-ISC funded care, who will actually see their rights to sue Canada going forward waived as a result of the final settlement agreement. Those children have rights and they need to be protected. If we collectively allow this to happen with no evidence from the victims impacted by this motion, then First Nations children and their parents and grandparents will actually be the very first group of victims to see the Canadian Human Rights Act compensation bargained away in over the 45 years since the Act was brought into force. This is crucial to understanding how dire the situation could be. And we want to end by saying that the Caring Society stands with those left behind, no matter how unpopular this makes us, because it is our privilege and our duty to defend these rights of these children and those who have had their rights affirmed by you in this process. Looking out for those who are left behind is exactly what human rights law is all about. That's what it was designed to do. And we ask that you again to take this into consideration, to make the best decision for children and their families who were so badly hurt by the Government of Canada. And to the government, you must do what the public asked you to do, to stop fighting First Nations children, to pay what the Tribunal and the federal court has ordered, and to do it without delay, and to work with those, including the Class Action Council, to have those rights vindicated. Subject to any questions from the panel, those are the submissions of the Caring Society.
Thank you very much. Member Lustig, do you have another question?
Thank you.
I can't hear you, but I guess that's no.
I think he was saying no. I think I've learned to read his lips through this process.
Sorry, again, thank you very much. No, I don't have any questions.
Thank you. Thank you so much.
Okay, thank you.
And thank you to Mr.
Thank you
Taylor.
again.
Very, very good backup from Mr. Taylor. Thank you so much.
Thank you. So we will now move on to the commission submissions. So I don't know if it's Mr. Smith or Ms. Wash, who will be speaking.
It's Mr. Jurisdictional. I'll be speaking on behalf of the commission.
Yeah.
I just wanted to check my sound, and just 2 minutes ago, of course, I got my internet connection is not stable. So I
Yes.
lose connection. I hope not. You are freezing on and
Yeah,
off.
we
Hear me?
lost you for a moment.
Okay. Does the sound okay at the moment?
Yes, now
Okay.
it sounds okay.
So I will proceed unless I get a message or everyone's frozen, and I will try my best to call back in. So I want to start by saying good afternoon to Madam Chair and Member Lustig and to Council and all those observing. My name is Anshumala Juyal, and I'm representing the Canadian Human Rights Commission along with my colleagues Jessica Walsh and Brian Smith. I want to start off by acknowledging that I'm making my submissions in Ottawa on the unceded, unsurrendered territory of the Anishinaabe Algonquin Nation, who have lived on and nurtured this territory for millennia. So it's tricky being last to speak. I have some comments. I don't think it's going to take more than 30 minutes, subject to additional time for questions. I plan to refer to a couple of cases in our book of authorities, so you may want to have that handy if you want to follow along in that way. I don't plan to repeat our written submissions, and the Caring Society has covered quite a bit of common ground, so I'm going to try and avoid repeating that. I would like to start, however, by asking the panel if you would like to direct my remarks to any areas that you're interested in hearing from the Commission, or if you have any questions up front.
Not for the time being. Member Lustig?
No, I do not know.
So I will start by discussing what I think are governing principles to help you make the decision you have to make today. So I think the parties agree in large part on the principles that govern this decision, whether it be with regard to the value of negotiating out of court path forward and the dialogic approach, functus or finality, and this panel's retained jurisdiction. Where the parties seem to part ways, however, is how these principles apply to the situation at hand. The Commission agrees with the parties regarding Justice Favel's obiter remarks, supporting solutions that the parties themselves develop outside of litigation. The court's words may be read as encouraging meaningful ways of implementing the tribunal's compensation orders. Justice Favel's comments also support final solutions sooner rather than later. The Commission supports all of these goals. Our understanding of the court's comments are that the compensation orders are the floor, and the work still to be done is to build upon those orders, including putting them into effect. In other words, all efforts should be directed towards implementing the orders rather than pursuing appeals or other litigation, such as the protective judicial review filed by Canada at the time the decision was released. The Assembly of First Nations says there are no analogous precedents to inform this decision. And while every case is unique, and certainly the facts of this case are historic and groundbreaking, you are not without tools to guide the exercise of your discretion today. And that's where I want to try and give you some assistance. And I'd like to talk about some of the cases on finality or functus. And we provide these 3 examples in our written materials. I'm going to go over them very briefly. There are cases where this tribunal has exercised its own retained jurisdiction. And I'm going to talk about those briefly. And there are even precedents for where this tribunal was asked to follow an out-of-court settlement and how it managed that situation. I will discuss that case law in more detail later. Suffice to say, for now, there's jurisprudence to guide your decision-making. First of all, I'd like to talk about the essential question you're being asked today. Does the final settlement agreement fully satisfy your compensation orders? That's the question Canada talks about in its reply, saying the question is whether the tribunal should now accept a historic settlement benefiting many as satisfying the compensation orders. So for me, this is where I struggle a little bit. Simply put, the question for you to decide is whether the final settlement agreement complies, fully satisfies, or implements these tribunals' compensation orders. And what does that mean? What does it mean to satisfy those orders? When I read that final settlement agreement, it reads to me as a plan or a promise to pay, a type of compensation framework of its own kind versus actual payment. If you look at a typical patient is granted, let's say $4,000, and there's an award that the respondent develop a human rights policy. What compliance or satisfaction of that means is not correspondence exchange between the parties where the respondent is promising to pay the $4,000 in the future, or that they've contracted a specialist in human rights who's going to help them draft that policy. Compliance or satisfaction of those orders is when the check is cut and that person has the $4,000 in their hand. It also means that that human rights policy is up, posted and published and accessible to the public. So those orders are actually put into effect. The same goes for the case at hand, I think. Money needs to be in the hands of those who were awarded compensation in order for your orders to be fully satisfied. They're orders for actual payment, not a plan to pay. On top, and I quote what the AFN says in their written materials, they recognize that the settlement is not an implementation of the compensation decision, but rather a complex negotiated resolution built upon your orders. And that's at paragraph 248. All the parties have recognized that there are some entitlements under the tribunal's orders that are not part of the final settlement agreement. The AFN in their written submissions in that same paragraph goes on to say, there's uncertainty in the number of complainants who may come forward and claim compensation, which may in turn lead to inconsistencies between your orders and the final settlement agreement. We heard more details from Mr. Cowper, identifying many ifs, maybes, and pilot projects to come. Counsel for Canada said yesterday, the fact that there are outstanding issues that will be determined at a later date should not prevent this tribunal from finding that it satisfies the tribunal orders. With all this in mind, the Commission's position is that the final settlement agreement does not comply with the tribunal's compensation orders. So that's kind of the first issue there. The second issue that I'd like to address is the jurisdictional issue that our friends at the Caring Society spoke to in some length. I'm not going to make comments in as much detail, but I will focus on this idea of finality. It's a really important foundational principle, and it's important first and foremost for those affected by the orders of this tribunal. That is the individuals who are awarded and are entitled to be paid compensation for the worst case scenario discrimination that you found and they faced. As counsel for the Caring Society said, certainty of outcome is important, and it's important for them. The question for you is how to balance finality with flexibility, and also, I would submit, fairness. The Commission submits that this tribunal has moved beyond the stage of deciding on the award of remedies themselves, which were grounded in evidence and based on a full hearing process, has moved on now to deciding how to effectively implement those remedies. And that's really what your retained jurisdiction is seized with at this point in time. So we've moved beyond the award of remedies to implementing those remedies. And that's the question before you. Have they been implemented? Have they been put into effect? We agree with the Caring Society that the identified victims and the quantum awarded are final and closed, and that part cannot be revisited. Everyone agrees that there's a need for flexibility and that this tribunal has a statutory mandate that should be broadly interpreted. However, flexibility and innovation, both in terms of how you interpret the Canadian Human Rights Act and the principle of functus, does not mean there are no boundaries. Our submission, based on the nature of your past variations to tribunal orders, is that you can clarify, you can correct, and you can supplement your orders. But we don't see examples where you've subtracted or removed substantive rights through amendments after the fact. So this is where there is no precedent. We provide examples of this tribunal's findings on the boundaries of its own jurisdiction in our written submissions, and I can point you to those to refer to. They're paragraphs 46 to 49 of our submissions. And there's 3 cases we cite as examples. Counsel for the Caring Society mentioned Grover, which is peppered throughout decisions of this tribunal, of this panel in particular. And that case really talks about retained jurisdiction being used to effectively implement remedies. So this case did not involve a change to remedial order, rather clarification of an order, and clarification in particular to ensure effective implementation of the tribunal's orders, which is part of your mandate, not just to create effective remedies, but to implement those remedies effectively. Hughes and Transport Canada is another example. There, this tribunal was asked to change an order rather than clarify to make it enforceable, and refused to do so, finding it was functus as the period of retained jurisdiction had expired. And I want to draw your attention to one of the passages there that this tribunal wrote at paragraph 61. It's tab 19 in our Book of Authorities, and I'll read at that point. Parties need to be able to rely on the finality of decisions. If courts and tribunals could continuously revisit and vary their decision, the administration of justice would not work the way it was meant to, and it would not be procedurally fair to the parties. When a party is not satisfied with the decision of this tribunal, it can bring an application for judicial review at the federal court. The last example I want to give to you as guidance is Burberry, and that's in tab 2 of our materials. It's another case of retained jurisdiction of this tribunal, and it involves the expiring of the period of time that it had retained its jurisdiction. And that retained jurisdiction only extended to overseeing implementation again. This tribunal found that where it was asked to change, where it might be asked to change an order or implement a different remedy, it's likely functus. So the key here at the end of the day is flexibility to ensure effective implementation. So that's the area where the innovation and the flexibility, as Grover talks about, comes into play. The Commission argues that retained jurisdiction doesn't render a ruling interim. The compensation decisions were reviewed by the federal court as final decisions. And as counsel for the Caring Society said, there's all kinds of complicated high thresholds. If you want to seek judicial review, it's very exceptional for something that is interim and preliminary, because it would be premature to seek judicial review if it's not a final decision. So the court reviewed those decisions as final and upheld not only these decisions as final, but the panel's retained jurisdiction, with what we submit is in regard to ensuring effective implementation of its orders. Nevertheless, the Commission agrees that the compensation framework leaves work to be done. We agree that the tribunal can continue to clarify and add to its orders, and it can give guidance to parties when they can't work out the remaining issues on their own. But the question today is whether this tribunal can undo the parts that were already done. And specifically by that, I mean take away or reduce entitlements that were granted. I want to clarify one of the points that came up in oral submissions from the Assembly for First Nations, and also in their written reply, paragraph 50. We wrote in our submissions, our written submissions, that this panel has authority to add or further specify categories of compensation beneficiaries. And they mentioned orally and in the written reply that there was no support for that. We did have a footnote in our materials, footnote 39, and it refers to a decision of this panel, and that's where those words come from. So it comes from 2020 CHRT 7 at paragraphs 51 to 52, and those are actually reproduced in Canada's reply. So those are the words of this panel when it comes to their retained jurisdiction, that they can add or further specify categories of compensation beneficiaries, but not take away from them. I want to talk about another consideration when we're thinking about functus. One of the factors you can look at is whether there's a lack of a right to appeal or a lack of a statutory right to judicial review. And I think Council for the Assembly of First Nations focuses on the lack of a right of appeal, but equally valid is whether or not there's a right to judicial review. And we do have that with regard to decisions of this tribunal. The right of judicial review allows a party to obtain the same relief through a slightly different mechanism. While a court on judicial review cannot substitute for the tribunal's duty, they can, as an appeal court or body could do, the reviewing court could return the matter back to the tribunal to carry out its statutory duty if the court found it failed to. In this way, the cure that an appeal could provide is equally available through judicial review. This is a vehicle to allow the originating tribunal to execute its statutory duty should the reviewing court find that it was not done. And this is really what functus would tie a tribunal's hands to and cannot be cured. And that's why you would want an appeal. Then it's an important factor to consider whether there's an appeal available to cure that issue. And judicial review, I would submit, you can find the same remedy that way. So where judicial review is available, it lessens the necessity for more flexibility in reopening the originating tribunal's decision. At the end of the day, when this tribunal is considering the question of finality, it must balance flexibility with fairness and access to justice, particularly where its decision may impact the entitlements of the victim survivors of discrimination within its statutory mandate. So that's who this tribunal should be concerned about, the victim survivors of discrimination within its statutory mandate. The last area I want to talk about is negotiated settlements. And I want to draw your attention to one of the cases and findings you made in one of your decisions. And that's at tab 13 of our Book of Authorities. The decision citation is 2021 CHRT 6. So again, 2021 CHRT 6. And I'm going to read from paragraph 133. This panel said, while providing agency for the parties to negotiate is important, the tribunal is ultimately responsible for ensuring that the CHRA is upheld. Accordingly, the tribunal may, in rare cases, decline to adopt a position negotiated by the parties. For example, Taylor, on behalf of Kevin Taylor, and Aboriginal Affairs in Northern Development Canada and Health Canada. This is a recent decision of this tribunal that involved discrimination in the delivery of services to First Nation adults with disabilities ordinarily resident on Manitoba reserves. The parties in this case reached a settlement where the complainant would receive personal compensation. And in addition, Canada was going to fund a research project with the aim of leading to systemic reform. All this was conditional on the tribunal granting the request for an indefinite adjournment. The tribunal refused, however, because of its statutory mandate to deal with the matters expeditiously. So this is an example of this tribunal balancing its consideration of a settlement reached by the parties and its statutory duties. I'm going to close by talking about the principles to guide your decision. In our written submissions, we spoke about the principles that should guide your exercise of discretion, should you find you have jurisdiction to vary the orders as requested. Our written submissions discuss how your focus should be on the human rights principles rather than class action principles. I want to close my submissions by focusing on the objectives you must keep in mind when deciding to grant either relief, and there's two sought by the Assembly of First Nations, whether a declaration that the FSA fully satisfies your order or that your order should be varied to adopt the final settlement agreement. The core objectives to balance, again, are flexibility, finality, and fairness. The tribunal has the power to clarify its remedial order in order to fulfill its mandate of making victims of discrimination whole. And I'm quoting from Grover there. That's at paragraph 23. So we would also submit that it's not only the power to clarify, but it's the power to correct or supplement your remedial orders when the focus again is on fulfilling your mandate of making victims of discrimination whole. Section 48.9 sub 1 of the CHRA says that proceedings should be carried out as quickly and as informally as natural justice allows, and I'm paraphrasing. This speaks to the balancing of innovation and flexibility with fairness, but always with the objectives of the Act in mind. At the end of the day, you will have to ask yourselves if the consequences of the approval or substitution of the final settlement agreement for your orders yields a fair result for those impacted. For example, consider the states as an example, who suffered the worst case discrimination and who benefit from your original compensation orders, who also saw these orders publicly upheld in federal court. Is a new order approving the final settlement agreement or varying your original orders fair from their perspective? Is the process to remove these entitlements fair? Would such a decision or process be fair according to the objectives of the Canadian Human Rights Act, using a human rights framework of analysis? Is such a variation to remove entitlement serving the purpose of making the estate victims of discrimination whole again? These are the questions you must grapple with. In coming to a final decision, you must exercise your authority to approve the final settlement agreement or to vary the terms of your original orders using flexibility balanced with fairness. You must consider what finality means to those impacted by your vision, to those who are entitled today to compensation by your orders. And you must ground your decision in the objectives of the Act that you know so well by ensuring the decision you make furthers your mandate, your statutory duty to make victims of discrimination whole. So those are my submissions, subject to any questions you might have, and I would like an opportunity also to consult with my colleagues before I wrap up my submissions, but I'd welcome your questions.
Thank you very much. Member Lastate, I don't see you, but do you have a question?
Yes, I do. So in the end of your submission, you spoke about flexibility and that you sort of suggested to us that we look at the human rights framework as the means by which we come to a flexible decision. So what kind of a flexible decision do you have in mind that would preserve the rights that have been negotiated, shall we say, and that are at least as good, if not better, than the ones that we provided for in our decision, but at the same time protecting those rights that have been reduced or eliminated? Where does flexibility come into play? How does that actually work?
Yeah, and it's a great question. And I think that's where Chandler kind of finished, saying that administrative tribunals have flexibility, but not explaining how that works practically speaking. In this case, I think our submission is that flexibility plays out when it comes to implementing an effective implementation of your orders, not to making different orders or taking away from orders. So I think that you may see flexibility in the way the Caring Society proposed with their red light, green light, yellow light option as well, where you can kind of work with parts where the floor of your orders are still maintained. And so I think in that way you can have some flexibility. And also certainly there's room for flexibility and innovation when you're working out kind of the operational and practical ways of implementing your orders, but not in touching the substantive rights that are given in those orders.
But the motion that we're considering, as I see it, doesn't go to implementation per se. It goes to the substantive aspects of our decision, the amount of money that we provided to certain groups, in particular, 2 groups that are now being reduced or eliminated. That's really, and the I guess the uncertainty with respect to Jordan's principal victims, by virtue of the fact that definitions and other means of determining the scope of that haven't yet been determined. That's that's what's at play here. Not how the notices are given out or any of that kind of thing. We're not into that. We're really into whether things are in or they're out. And what I'm hearing from you, and I think from the Caring Society, is that essentially everything that has been taken out, so to speak, should be put back in. That's it. And I don't know about that being an exercise in flexibility. That's an exercise in, I guess, reminding the parties that our decision stands, notwithstanding anything. That's not, you know, an innovative or flexible position with respect to those issues. That's basically our decision stands, and you know, that's it. Work it out. I don't see that as a flexible position. So I'm not being critical here. I'm just, you know, when you end up by saying that we have all this flexibility, but the real core issue that's before us is one that you really don't feel we should have any flexibility in, that doesn't really help in terms of finding a solution to this that wouldn't result, you know, in the poison pill. That's my worry. I guess I'm making a statement, not a question.
No, yeah, and I fully agree with that statement. I don't think that the flexibility extends to those realms. I think the flexibility extends to certainly if you're looking at implementation only, but not the substantive changes that you're talking about there.
Thank you.
Thank you. You wanted some time to confer with your colleagues?
Yes, please.
So how long would you need?
Probably 10 minutes. Would that be okay?
Sure.
Okay. Thank you.
We'll take 10 minutes. Please be on time. Time is running.
Recording stopped.
I don't know if, we're now at the time of reply. I don't know if the AFN would like a break, or if you're ready to proceed and you want a break in the middle, just let me know.
Yes, Madam Chair, and
Oh, I'm sorry, you're on
members.
mute. I'm sorry, we missed this part of it.
Am I now unmuted? Can you hear me, Madam Chair?
Yes.
Okay. Thank you,
Yes.
Chair. Member Lustig, I think I will start and do some of the reply for the AFN, and then Mr. Wutke will complete the reply for the AFN, and then Canada, I think, has some brief submissions. And we may need a break, but I'll take a start at it if I may.
Yes.
So let me say, in the general reply from the AFN really is the following, which is both the Caring Society and the Commission's approach to jurisdiction is flawed and only addresses some of the relevant factors which you have to consider in a relation to jurisdiction. But that flaw itself illustrates the flaw in the approach to the motion on the merits of the motion. Because in our respectful submission, if you listen and reflect carefully back on what the Caring Society has said, in effect what they've said is the negotiations that have been carried out for the past 2 years could not go beyond certain guardrails. They said there was a floor and that you can't approve a settlement that in any respect goes below the floor of some of the previous orders. And I'm going to illustrate it in reply. That is, with respect, flawed. If you go beyond that, though, however, in our submission, once you go beyond the question of whether you have the jurisdiction to approve the settlement agreement, the rest of the inquiry is very straightforward. And Ms. Clark's very impassioned submissions effectively fall short of supporting any general criticism of the FSA, which represents this monumental achievement that builds on your work and completes it in a way that is in the interests of the children and fulfills your mandate. So those are the two fundamental points I want to make. So let me say why, in reply, I say that the approach to jurisdiction is flawed. Firstly, and let me put it this way, a couple of times Ms. Clark in her impassioned submissions, and very effective submissions, said, well, we need to continue with the compensation framework. And so the path forward, as I hear her submissions, is we go to the compensation framework, we complete the work that needs to be done there. That's the path forward. Well, with respect, if the motion's dismissed, that's not the next step in these proceedings. The next step is the appeal to the Federal Court of Appeal has to be resolved. There's outstanding litigation that leaves the rights that you've done uncertain. At this point, it's subject to further appeal proceedings. And then secondly, with respect to the compensation framework, that framework is within your jurisdiction and is confined. It can't give the rights to the many additional benefits and many additional tens of thousands of children who have rights under the FSA that can't be included in the compensation framework. So the net effect of that, and that's why I say it's deeply flawed, is it ignores the ongoing risk of ongoing litigation, which a settlement agreement directly addresses. We resolve that. The Federal Court of Appeal is resolved with the approval of the FSA. Secondly, the compensation framework becomes reconciled and folded into the process that is part of the FSA, and you have, and that's why I say when you get to balancing, you capture all of the additional benefits by endorsing the FSA. And so in reply, I say they have not taken into account that you must have the jurisdiction here that includes recognition that the rights are not final, and I'll give you a reference to their written submissions, and I believe it's in paragraph 9. Ms. Clark, in her written submission, says the Federal Court Trial Division put a final stamp on the finality of your orders. That's not so at all. A JR decision simply decides that your decisions were reasonable. You then have your continuing jurisdiction subject to an appeal of the JR decision. So there's nothing final about the federal court decision except within the confines of the federal court. So the point I'm making is they have put as a mark of finality a stage in the litigation journey. What we have done is achieve finality in all the litigation, plus all of the human rights tribunal proceedings, plus the class actions. And we've done so over the last 2 years in a way that's comprehensive and in the best interest of the children and their families. And so with respect, on the first point, they have a flawed approach to jurisdiction, and with respect, the commission does similarly. As soon as you recognize that in part, the motion is asking you to endorse a settlement, then the idea that somehow we're only dealing with implementation is demonstrated to be flawed. The second point in relation to the flaw in jurisdiction is that the proposed distinction between entitlements and implementation in this case is deeply flawed. So the compensation framework and the work to be done in relation to the compensation framework includes many, many decisions that would affect who gets benefits, how they're identified, whether they receive the benefits. This is not a question of outside forces. I think Ms. Clark at one point said, don't let the outside forces affect your decision. The forces that require the professionals here to engage with well over 100,000 people have not been concluded in the compensation framework. The work to be done in the compensation framework would have a profound effect on the numbers of people who successfully claim, how they claim, etc. So my point is that the second flaw in jurisdiction depends upon you accepting a bright line distinction between entitlement and implementation. And that, in this context, simply cannot be so. I'll give you one just example. There are many other examples. 2 or 3 times, Ms. Clark said that the compensation framework made it clear in relation to ISK, non-ISK, that there were other custody arrangements that could be included, or should be included, or must be included. Well, the definition of that, by its nature, is open-textured. That's not finished. And anything that would be engaged in a negotiation around that would mirror the negotiations we've been involved in for the past 2 years. Those kind of details are not merely about entitlement. They also include, very importantly, who, what, and how are people to receive the benefits that are in this. So the point I'm making, to summarize, is that the second flaw is that any process, whether it's the compensation framework or under the FSA and under the class action, will have a profound influence on who and how many claimants receive compensation. And so the distinction in this case between entitlement and implementation is a illusory distinction. So summarizing my reply with respect to jurisdiction, your jurisdiction is not limited to considering whether or not the benefits are above the proposed floor. That's an artificial distinction. Your jurisdiction includes taking into account the settlement of the parties, the outstanding litigation, the situation of the framework, compensation framework, and that jurisdiction does not stop at, as it would be, in saying you can't tamper with any of the entitlements whatsoever. You need to consider the FSA in light of the balance that Commission Council and the end of their submissions appeal to you. And as I say, I'm going to submit when you get there, the answer is straightforward and obvious.
Can I ask you a question? Excuse me, can I ask you a question? Yes. So what you've just finished telling us or arguing is that you feel that the Caring Society's submissions with respect to finality are flawed, and that we have the jurisdiction as opposed to not having the jurisdiction, and that the distinction between implementation and the remedy itself is not something that would prevent us from having jurisdiction. Do I have that correct?
Correct.
Okay, so this is sort of the same question that I asked before of two other counsel in different ways. I asked Mr. Watke earlier whether if that jurisdiction is, as you put it, we would then have the latitude or the jurisdiction to find something other than what you've asked us to find. And I asked counsel for the CHRC just a moment ago, where do you get into flexibility with respect to the issues that are really at the heart of this particular motion, those areas where there is, as someone said, not a one-for-one. Is it your position as well that there is essentially, even if we have jurisdiction, no flexibility that we have to do something different than what you're asking? If we have the flexibility, I asked Mr. Watke this, and I put to him a condition, for example, of endorsement, and I think he responded by saying something about a suggestion rather than a condition, which is a little bit different. But do you have sort of the same view that at the end of the day, if we do have jurisdiction, we may have jurisdiction, but it's not to do anything other than what you've asked us to do? Is that your position?
So I think my answer is consistent with Mr. Watke's answer, which won't surprise you. But let me put it in the context of replying to the Caring Society's traffic light proposal. With respect, the motion doesn't invite you to engage in the traffic police role. And I want to be consistent with our position on jurisdiction. If you were to dismiss this settlement and say, we're not going to endorse the settlement, where would we be? We would potentially be in the Federal Court of Appeal, and we would potentially be in the compensation framework trying to do the work. And my point is that work would be vast and ongoing and uncertain and take a great deal of time, but you would have a plenary jurisdiction over that process. So consistent with my position, that would include, for example, people not receiving entitlements that up until the framework discussions you thought you could deliver for a whole variety of reasons that we've discovered over the last 2 years. But with respect to your approach to this proposal, I do want to say that the parties, and Ms. Clark said, in a sense, you've been put in a dilemma. I would put it more accurately this way, is that what the parties did was go away in light of all of these various factors to try to reach a settlement that achieved the goals that we set out in the motion. If those goals are achieved, then what you can't do is order, we want this clause changed or that clause changed. Of course you have jurisdiction to turn us down. And you could turn us down for a narrow reason or a broader reason, and then the parties would have to consider the basis on which that was turned down. Obviously, if you were to say, well, we are appreciative of the progress, but in this one particular, that stands in our way after careful consideration of approving it, then the parties would have to consider whether they could make adjustments to include that objection. I think that's the most comprehensive answer I could give.
Thank you. I appreciate that.
And
Thank you.
It does give me the opportunity to say, not only do I not think you're in a traffic situation, if I may, with respect, say that there really is, in respect of the Caring Society, really only one light in relation to this motion, which is 4 red lights, because the areas in which the FSA improves on your arrangement can't be approved by you separate from turning down all 4 red lights. That's a profound, let's be clear about this, that's a profound change collectively to the FSA and the terms that have been agreed to by the parties. And so with respect, it doesn't offer a path forward in my respectful submission. So can I address one aspect of that, and that is really, I think Ms. Clark came up with really the yellow light on the brake in answer to your question, Member Lustig, about the Jordan's Principle uncertainties. And the submission I made to you and I just want to be clear, in my respectful submission reply, Ms. Clark didn't really effectively answer the Jordan's principle process on the basis we tabled it, which was to move forward in the process to finalize the Jordan's principle process. It requires us to have approval of the settlement agreement in order to carry out the remaining proceedings. And so those will be wrapped up to being approved by December. But just to be clear, it's based on our position is based on the process and the progress we've made with the experts. We can't go further with our communities without the assurance that what we're doing further is actually effectuating the settlement rather than thinking about whether there should be a settlement. So whatever uncertainties exist with respect to Jordan's principle are part of the work that has to be done in implementing the FSA. They're not part of a gate as to whether or not we should have a settlement. The other comment I would make, and my colleagues have said, to be clear, and I think you asked this question a couple of different ways, and we appreciate, I think, all counsel, the challenges you have, and I've said they're perhaps simpler than they were put up to you and by my friend from the Caring Society. But let me be clear and say the dialogue between the Assembly of First Nations and the Caring Society has been ongoing. And it's covered by, as Ms. Clark pointed, much of it's covered by settlement privilege. So the point I would make is you ought not to think that that's an immature dialogue and that somehow if you toss it back to the parties, it'll all be straightforward. And let me give you in the record an obvious example of that. If you go to, and you can make a note of the Exhibit A to the affidavit of Ms. Carr, dated August 5th, 2022, in the document authored by the Caring Society, in respect of benefits to adults, they said that they were prepared to consider the benefits to adults to be reduced so long as, and I'm going to read their language, so long as they should not be unduly infringed, save and except where lower amounts are just compensation for the infringement of dignity. That's the type of matter on which the parties to the FSA have been negotiating for 2 years. How do we fulfill the mandate of this tribunal's orders and the claims which have been built on in order to do so justly? What's happening here is the question simply, were we entitled when we were asked to go and negotiate to do that in a way that broadly looked at the question, or were there floors below which we could not go and which the tribunal cannot go? If you recognize that you have a plenary authority over this, in my respectful submission, the terms of the FSA fully perform the mandate of this tribunal. In fact, they go far beyond what the tribunal can do. And I think Mr. Wuttke wants to speak to this, but I just want to say for those listening and obviously members of the tribunal, we shouldn't forget that although we've been talking about the changes which are to some of the entitlements that were spoken of in some of the orders, understand that the vast effect, overwhelming effect of this settlement agreement is to grant greater funds to people than you were entitled to grant, to tens of thousands of people, and to include tens of thousands of people you weren't entitled to include. That's the achievement of the FSA, which we're so passionate about capturing and enabling to be effectuated if you approve the FSA pursuant to your jurisdiction. I have just one final comment, which is I do want to address the question of the form of the order and the need for a decision. And we've had some correspondence with the tribunal on this. You'll know from the prayer for relief in the notice of motion that we've asked for a declaration that the final settlement agreement be approved or be declared to have satisfied your previous orders, and in the alternative that any variations reflect amendments, if necessary, to your previous orders. And I want to be precise about this because I do not agree with Ms. Clark that you have to troll past all of your other orders and decide whether there's a specific amendment here or a specific amendment there that's necessary. What we would propose is that the form of order firstly declare that the final settlement agreement satisfies your compensation order and related orders, and that to the extent that the terms of the final settlement agreement vary from your previous orders, that the final settlement agreement terms govern. In other words, we say by order, you can embrace the necessary variations by embracing the final settlement agreement. It isn't necessary to do the scrivening or detail that would go back and consider what specific orders on specific grounds would need to be amended. Now, subject to that, I'll give the podium over to Mr. White. And I've been told I need a break.
Oh, thank you. How long do you need? Mr.
10 minutes is
Whitke?
fine. Thank you.
You said 10
Sure.
minutes? Okay, thank you. We'll take 10 minutes.
Recording stopped.
Okay, I think everybody's back. So, Mr. Cowper?
Thank you, Chair. It isn't really a point, it's a point of logistics. As you may know, we shared your previous correspondence about this hearing with the federal court, and I wanted to provide an update. Pursuant to a case management conference, the federal courts asked us to update the judge with respect to whatever happens today and whatever you say at the end of the hearing. And then the hearing is scheduled before the federal court to take place on the 20th, next Tuesday, in light of the funeral of the Queen on Monday. And so we'll be reporting at the end of today, and obviously you're aware of the scheduling of the federal court and the implications of the interaction between the work you have to do and the work of the federal court. Thank you.
Thank you.
Yes, good afternoon, Chairperson Marchand and Member Lustig. I won't be very long in my reply. So my friend from the Caring Society talked about their interest in leaving no child behind. Your orders, the orders of the panel do leave a number of children behind. In order for a child to receive compensation under your orders, they have to meet 3 criteria. They have to be removed from their parents, their home, I should say, their homes, their families, and community. This leaves out every First Nation child that's been placed into care under Canada's discriminatory system that were placed in their First Nation community. Those children would not receive any compensation whatsoever under your orders. There are other children that are left behind, including all the people from 1991 to 2006. In your orders, you also stated, which the Caring Society picked up on, that not all JP service, Jordan's Principal Services, will be covered under your orders. And there's also the issue of non-ISC funded placements or alternative cares. And again, with respect to that, they assert that, we're looking at the discrimination. And they state that the nexus of your orders deals with the removals. And that the removal itself and the fact that there was no prevention is the trigger for compensation. Again, that is not correct. If the trigger for compensation was the removals, then it would include all First Nations children placed in their own communities. But clearly they don't. What our settlement agreement does, it balances all these interests. We add children to compensation. We add children that are excluded from your orders that meet the same category and criteria as those children that were discriminated, except that the ones that are placed off to communities would get compensation, the ones that actually stayed in their communities wouldn't. We correct that problem. The AFN alone is asking you not to leave any children behind. The Caring Society suggests that your order should stand in their final. Well, if that's the case, then all those children that were apprehended would never receive compensation. We ask that you bear that in mind, the benefits of the compensation that we're seeking. Secondly, the Caring Society refers to the fact that not all rights holders are in agreement with the settlement agreement. They point to the Federation of Saskatchewan Indian Nations resolutions found in the affidavit of Dr. Blackstock. And I would know when it comes to, and this is at Exhibit C at Blackstock, they include the motion from Saskatchewan. The AFN would note that that resolution is a resolution of the Health and Social Development Secretariat. It is not a motion or a resolution of the Federation of Sovereign Indigenous Nations. It is from their Health and Social Development Secretariat, which includes child and family service agencies. Now, what Ms. Clark did not describe is the fact that FSIN, who did want to intervene, withdrew. And what they say in their letter, in withdrawing, saying, further for greater clarity, the FSIN does not intend to seek to on any of its previously filed materials in support of the position on the joint motion. So essentially what they're telling the tribunal, those resolutions may be there, but for all time after this, we are not going to rely on any of that. That's what the Caring Society failed to disclose. Now, with respect to the other motion that she includes, that Dr. Blackstock includes at Appendix D, is from the First Nations Summit. Now, we would note that the resolution speaking to compensation, it definitely is from the First Nations Summit. We have no question with respect to its authenticity, but we would note that the person that moved that resolution was Mary Teegee, who was serving as a proxy for the Sistelia Carrier Nation. You will see from the responses from Dr. Blackstock from her cross-examination questions, Mary Teegee is a board member of the First Nation Child and Family Caring Society. The AFN would argue that there is definitely some apprehension by child welfare agencies, but they are not the rights holders. First Nations are the rights holders, not the agencies. Now, my friend from the Caring Society and the Commission talk about the dangerous precedent that could be set. But they both admit this is a novel case. It's unique. There's no other case like it in Canadian history. There may never be a case like it in Canadian history. They talk about, we all agree that no precedents exist. And it's precisely that point I'd like to remind the panel. No precedent did exist when we first brought this complaint to the Canadian Human Rights Tribunal. That complaint was dismissed by the tribunal. The original complaint was dismissed on the basis that no comparator group existed. The Assembly First Nations and the Caring Society appealed that to did a judicial review on that to the federal court. They agreed that that proposition that was brought forward by the Canadian Human Rights Tribunal was not sound. That was appealed to the Federal Court of Appeal, and again, we appealed that, and we defended that appeal, and we were successful, and the matter was referred back to this tribunal. Right from the beginning, when we filed this whole thing with the Caring Society, there has been no precedent that governs any of this. And I don't think that that should be a prohibition. This is a groundbreaking case. This panel has changed the law across Canada for the benefit of all First Nation communities. And that is a positive aspect. What the real dangerous precedent is in this, and just for some context, First Nation citizens, First Nation communities normally don't resort to the human rights regime, normally because individual rights always trump collective rights in those fora. The real dangerous precedent that could be set by this panel is that human rights processes trump the collective rights of First Nations. That will forever set back First Nation collective rights for another 100 years, perhaps. What essentially we're saying is that a First Nation negotiated settlement based on collective rights that will basically improve the benefits and include more people should be dismissed because of human rights processes. That is sending the wrong message to every First Nation citizen across Canada, every First Nation community, and every Indigenous community globally. Collective rights of peoples, of Indigenous peoples, mean something. The human rights rubric and framework where individual rights always get to trump collective rights should not continue in the context of First Nation rights. The collective has the rights, the collective has to survive the future. Otherwise, we're perpetuating a system of assimilation, genocide, where our nations will at some point come to an end. That's the dangerous precedent. Asking the question another way, and more importantly, the AFN would say that this tribunal must have the jurisdiction to endorse a First Nation settlement which supports First Nation-led processes, which provides greater benefits for First Nations individuals and claimants, and that is reflective of the First Nation will, the collective will of the First Nations. Tribunal must have jurisdiction to make a ruling in favor of this. To rule otherwise would fly in the face of reconciliation, self-determination, and everything we've been doing over the last 20 years with respect to collective rights of First Nation communities in Canada. Essentially, both Caring Society and the Commission are asking you to ignore the First Nation rights holders by not approving the settlement. I would like to finish off where we started. This case is about First Nations children and families. They are essential to the collective. They are essential to our nations. They're essential to the ongoing cultural and traditional knowledge of our communities and nations, our language, our customs, our legal precedents, our rights, our customary legal processes. All that is embedded in the First Nation family, transmitted to children, and it forms the basis of our cultural survival and the survival of our very nations. The AFN has always approached this case looking at future generations. These children are precious to our communities, they're precious to all of us. This agreement will provide compensation to tens of thousands of First Nations children. It'll offer more compensation than this tribunal could order because of the statutory limit that's imposed on the tribunal. It'll also extend compensation to tens of thousands of kids who aren't covered under this tribunal. It'll also extend compensation to those children that were apprehended under Canada's discriminatory system, but remained in their communities. It is a fair deal. It makes many compromises. It provides compensation to those children. I would leave off by saying, there is a lot at stake here. But it is a fair deal. It balances Canada's interests, First Nation interests, it provides compensation, and it reflects the integrity of self-determination of First Nations and Indigenous peoples. So based on that, we ask you to grant the relief the AFN and Canada are seeking. Subject to any further questions, those are the submissions of the Assembly of First Nations.
Thank you very much. Any other question?
Yeah, I have a question. I just want to get clarification. At the beginning of your last remarks, you were talking about children who were left out, you used the words left behind, I think, by our original or our current decision. And I want to understand exactly what you mean by that. And I want to ask you specifically whether it's your view, and this is why you just said what you said, that our order did not include First Nations children who were removed but not put in care that was paid for by Canada. Is that's your view that our compensation order did not include that? That's your interpretation?
Well, I mean, as far as our view on removing kids, I mean, it's twofold. First of all, the order is specific. You have to meet the three criteria. You have to be removed from your family, your home, and your community. If you're ever removed from your home, regardless, and you're placed in a First Nation, in your community, your First Nation community, you're not entitled to compensation. They suffer the same discrimination as every other kid that was apprehended under that racist regime, but they would not be entitled to compensation. With respect to the other children, the non-ISK children, there's just not enough information right now. Were they actually apprehended based on Canada's discrimination? You know, as my friend from the Caring Society said, that, you know, there's no prevention services, all the rest of the stuff. That might be true, but this case reflects around Canada's discrimination. Some of those children were not removed under Canada's, you know, because of Canada's discrimination, they were removed under provincial processes. Or they were moved under provincial authorities, whether it's the provincial government, legislation, moving kids and putting them into, you know, customary care, other places. We don't know if those children are, were removed on this process through the federal process, or was it a provincial process? There are still many unanswered questions with respect to those children. We just have no idea. And the only way we can get that information is through interrogatories or getting them to testify or seeking other evidence. Some of that evidence may not exist. There's just no way. If you look at those children making claims under either the compensation process that you outline or whether it's through our process, there is no data to say whether or not they were entitled to compensation. The Caring Society's position is, well, it's clear they're discriminated against, pay them out. But we really don't know that, and there's no way of us ever determining that. So that would be my answer to your question.
Okay, thank you very much.
All right, subject to any other further questions?
No,
thank you.
Thank you. Oh, thank you very much. So we will now hear from Canada for their reply, unless you need a break.
No, thank you, Chair. We're prepared to go forward.
Please go ahead.
Thank you. First, with regard to the argument as to whether the tribunal has the necessary jurisdiction. Effectively, the argument of the Caring Society and the Commission is that there is no ability in the representatives of the rights holders to negotiate an agreement which in any way derogates from the prior decisions of the tribunal. If this is correct, then it follows that litigation would become the only path by which any adjustment to those orders could be achieved. This would negate any possibility of the parties carrying out the exhortations of Justice Favel that negotiation should be both fostered and encouraged, and would be directly contrary to the intent of those statements. The agreement, which is before the tribunal, was, as we have said, negotiated over a period of about 1.5 years by class counsel who were appointed by the federal court to represent the class, which includes the individuals covered by the CHRT orders, and the Assembly of First Nations, who, it's common ground, are the representatives of First Nations rights holders. Contrary to the submissions of Ms. Clark, this is not a case in which Canada dictated an approach. In fact, it's quite the opposite. The settlement was intended from the first to be First Nations led. Its implementation is to be culturally sensitive and trauma informed, and it maintains a strong First Nations control of the process, subject to the supervision of the federal court. Now, the settlement provides that on its approval by this tribunal and the court, and following, of course, the expiry of all applicable periods for appeal or judicial review, Canada will withdraw its appeal to the Federal Court of Appeal. But the effect of what is being argued by the Caring Society and the Commission is that the only route forward would be to continue to proceed to the Federal Court of Appeal. And that would do nothing but encourage the very litigation which the parties are intent on avoiding through the consensual agreement that they have reached. Now, the important consideration is that the settlement is, of course, a consensual settlement amongst the rights holders and class counsel representing the class. And in order to make changes, of course, to the final settlement agreement, it would be necessary to achieve a consensus amongst all of those parties regarding the changes. The difficulty is that the delay which would be involved would very significantly impact on the ability to proceed to implement the compensation provided by the agreement. There's an inherent difficulty with the red light, green light approach proposed by Ms. Clark, because it would necessitate that the federal court process await the result of some form of review, because the final settlement agreement provides that the approval of this tribunal is a condition to the implementation of the settlement, and the federal court cannot approve the agreement without this tribunal having previously confirmed that the settlement approves its orders. So we would be stalled in the federal court process for an indefinite period of time. And it effectively would result in a situation in which there was substantial delay with no guarantee that a consensus could be reached with regard to any proposed changes. Now, dealing with the argument with regard to non-ISK funded placements, there are 2 points I would like to make. The first point is that this issue is entirely new. There is no evidence before the tribunal regarding these children, and in fact, the panel has not at any point been called upon to consider whether or not they are properly included under its orders. So it's an entirely new point that the Caring Society seeks to raise. Importantly, though, it's not the case that children within those circumstances, if I could put it that way, are called upon to release Canada from any claims under the final settlement agreement. And that is because Article 1, the definition section of the final settlement agreement, defines the removed child class so as to exclude those children from its purview, because it requires that the placement have been ISK funded. What that means is that it is only the class members who will release claims against Canada. These children would not be class members and are therefore completely unaffected by the settlement. So there is no prejudice to those children in terms of having the settlement approved because they remain free to assert their rights. Now, the overriding issue in our submission for this tribunal is to determine whether it is prepared to recognize that a comprehensive settlement which expands significantly the coverage of children covered by the CHRT order and is supported by the appropriate representatives of the First Nations, including the Chiefs of Ontario and NAN, and that has the support of the representative plaintiffs in both class actions, that is the Machoon class action, the AFN class action, and the Trout class action, should receive the approbation of this tribunal. The tribunal is being asked to confirm that, as my friend Mr. Watke has said, this is a fair settlement. This is a settlement that provides comprehensive benefits to an extremely wide range of children who have been impacted by the discrimination which this tribunal found to exist, and extends those benefits back to 1991 to a time period 15 years before this tribunal's ruling could have effect. Canada, therefore, very strongly supports the application of the AFN to have this tribunal confirm that the agreement does indeed satisfy its orders, or alternatively, that this tribunal amend its orders so as to have them conform to the provisions of the settlement agreement. And thank you for your consideration. Those are our comments.
Thank you very much. Will there be another person speaking on behalf of Canada, or that was all?
No, there will not. We are
Okay.
content.
Okay, thank you very much. We will take about 10 minutes. I need to confer with Member Lustig, and we'll be back after that.
Recording stopped.
Everybody's there?
Recording in progress.
I believe that everyone is there. The reason why I'm saying this is that I don't see all of you on the screen. Thank you to all the parties, to everyone who has worked very hard leading to today. We appreciate the parties accepting tight timelines, and we know that you all worked very, very hard. You've all admitted in some way that the matters are novel and complex. So the panel, unfortunately, cannot issue a ruling from the bench. And we want to take the matter under reserve. And we also reserve the right to ask further questions should we need to ask further questions. So on that note, we will adjourn the hearing and take the matter under reserve. And we want to finish by honoring the children that are at the center of this case. Thank you very much.